Please, your lordship. Also, I'm paying for listing of a similar matter, lordship. It is fixed on 27th, lordship. A similar matter, lordship. It may be taken with that matter, lordship. That's my humble.
May I please, your lordship? I beg to mention for listing of a writ petition in addition column, lordship. What happened, lordship? On last occasion, it was directed that list this matter after 4 weeks. Now 9 weeks have elapsed, lordship. And petitioners are not getting anything. They are contextual workers, lordship.
When do you want it?
On next Friday, lordship.
It's 27th.
27th, yes.
27th will not be. Choose a date next week.
Next week. On Monday next week.
All right.
All right. Much obliged.
May I please, lordship? If is others, otherwise, the intermediate lordship, madam. Item number 12 may be taken on the second half, madam, or 2 madam. Some difficulty in the first half, madam.
All right. Yes.
Deeply obliged, lordship.
May I please, your lordship? Lordship, with the consent of other side, I beg to mention item number 4, lordship. Kindly, matter may be taken after 1 week, lordship.
After
1 week, lordship.
you are for whom?
I am for respondent, demands autonomy.
Respondent means NC Hills.
Yes, lordship.
Achha. Your name, please.
J. Gogol.
Ms. J. Gogol, learned counsel appearing for the respondent. Prays for adjournment in this matter for a week on the ground stated by her. Full stop. Since the prayer is made with the consent of the opposite party, same stands allowed. List accordingly.
May it please your lordship. Lordship, I beg to mention a hearing matter which was listed in last December after 2 weeks. Lordship may give you any date starting on February 6th week, my lord.
Hearing matter, is it a fixed matter?
No, lordship, it was brought up by mention, my lord, prior to the winter vacation. It was listed after 2 weeks. So after
First, we'll have it for orders, then we'll see. 6th February orders.
6th February order.
Orders.
Deeply obliged, man.
May I please your lordship? My lord, I beg to mention a writ petition for listing. My lord, the matter pertains to promotion matter, my lord.
Promotion. You wait, what is the urgency?
My lord,
What is the urgency? You wait, it will come. Not now.
My lord, item number 7, the company matter. The respondent number 4 has filed a submission in near about 226 pages. So we seek time for filing a rejoinder and for further. So 2 weeks time I can.
Who is for respondent number 4?
Yes, I am appearing for respondent 4.
Sure. Mr. J. Sahu. When counsel for the applicant submits that a copy of the written submission
By respondent
of the respondent number 4 has been recently served upon him. Since it is a voluminous document, hence he be granted how much time?
2 weeks time.
2 weeks time to examine the same and obtain necessary instruction. Full stop. Mr. G. Khandelia, learned counsel for the Mr. Sahu is not for the applicant, he is for the company petitioner. And hence Mr. G.K. Khandelia and Miss
And Rahman,
Rahman
led by
learned counsel
Mr. K. Goswami.
are present before this court and do not have any objection if the prayer is allowed. In view of the above, let this matter be listed again after 3 weeks. Yes.
Your lordship, I beg to mention for listing WPC 6327 for listing, your lordship.
Why?
So it's a reason for urgency. It's a delayed.
What is the urgency?
It's a delayed pension matter. So there's an urgency.
Pension matter.
Yes, sir.
Which department?
I think it's the forest department.
I think you don't know. 8th February, right?
8th
Put the date 8th February.
Your lordship, there's further two similar WPC for listed for the listing, WPC 8642 and 4720.
All pension matters.
No, there's are for payment regularization. Payment regularization.
Those will not grant. Pension matter allowed.
18th February, your lordship.
8th February.
8th. Thank you, your lordship.
Your lordship. Item 17, I am for the respondent, my lord.
Yes.
Maybe taking it at 2, my lord. In this matter, an appeal is paid. I have filed, my lord. I have come to know, my lord, against the single bench judgment, my lord. So I just to take information in this regard, my lord. Maybe taking it 2.
Yes.
may it please your lordship. Well, in this case, the constitutional validity of a clause brought in by an OM dated 18th of January 2018 is under challenge. My lord, the entire issue hinges on that the benefit which is provided under the constitution to the members of the reserve class, that when they get an accelerated promotion under the 77 amendment, they also get an under the 85th amendment consequential seniority. That's a settled position. In Assam, in 2016, an OM came where an offending clause was brought in, where the Assam government wanted to form a quota for the general, whereby they wanted to debar people from us from going to the higher cadre on the ground that if we get seniority in the lower cadre, we will be debarred. So this was taken up, and in Bhagwan Pater's case, where the constitutional validity, and on June 6, 2022, a judgment which has gone in our favor of the reserve was passed, whereby the court categorically held that the reserve are entitled to the accelerated promotion and consequential seniority. And moreover, they are on merit when they go to the higher cadre, because as Lordship knows, in the higher cadre, it is merit-based selection post. So when they go to the higher cadre, there cannot be any bar, because that goes against R.K. Sabharwal Constitution bench. Because Sabharwal has said when the reserve go, they compete with the general and they go as a member of the unreserved. So no one can bar them from competing. That's a settled position of Indra Swami. There is no dispute about it. So I'll take your lordship to the operative part of the judgment, from where I will place my case. The lordship will come to page 103 of the judgment.
Yes,
This was the offending clause. Whether clause 4 in violation of section 5 of the 78 Act and therefore liable to be struck down. Clause 4 of the offending office memorandum provides that in a given situation, when the percentage earmark is achieved, but some reserve category candidates who on their own merit are entitled to promotion, his or her promotion shall be considered on merit, subject to the further condition that the said person has not gained any seniority by way of accelerated promotion. This is the finding of the learned single judge. Thus, from a reading of clause 4, it is clear that a consequential seniority is withdrawn for those people belonging to SC or ST who are eligible for promotion on merit, but has got accelerated promotion. The said clause nowhere declares that the policy of consequential seniority shall henceforth not be applicable to all the promotions made under section 5 of the 78 Act, because power flows from the 78 Act, which is an act which is in operation in Assam since the last 40 years. That being the position, this is important. This court unhesitatingly holds that the policy of providing reservation in promotion with consequential seniority being holding the field as per OM dated 12/3/2002, the state is not within its competence and jurisdiction to deprive such service benefit to a meritorious reserve category candidate, and that too without expressly bringing such policy by superseding the benefit granted under OM of 12/3/2002. Well, I'll come to this OM later after I complete. The aforesaid determination can be summarized in the following manner. The policy of the state in providing reservation and promotion with consequential seniority is discernible from section 5 of section 78 read with OM dated 12/3/2002. The office memorandum dated 12/3/2002 shall hold the field till such policy is expressly repealed by the state. 3. OM dated 3/6/16 is notified laying procedures for collection of quantifiable data on backwardness and inadequacy of representation and determining efficiency in administration while giving effect to such policy of providing reservation. Giving the dicta of Jarnail Singh, the OM dated 3/8/16 cannot sustain so far as the same relates to the collection of quantifiable data on backwardness. Next page. The determination of cadre as a unit for collection of quantifiable data as laid down in OM dated 3/8/16 conforms to the mandate of Jarnail Singh and Nagraz, and therefore the same is upheld. The procedures laid down for determining efficiency in administration not being arbitrary, not being based on any extraneous consideration, the same is upheld. Article 16(4)(b) enables the state to carry forward vacancies, and vacancies carried forward, it cannot be excluded in the ceiling of 50 for the year of filling up vacancy. Section 5A of the 78 Act permits carrying forward vacancies, and therefore the policy of carrying forward as provided in the office memorandum dated 3/8/16, not being arbitrary and not being based on any extraneous, is upheld. Giving the dictum in Janal Singh, the judgment made in Equality Forum 1 relating to collection of data to determine backwardness has become redundant. Article 16.4 and 16.4 being enabling provision, the state is at liberty to implement its policy of giving reservation in promotion with consequential seniority, at liberty to provide for reservation in promotion without consequential seniority, or at liberty not to provide for reservation in promotion. However, while implementing, adopting, changing such policy, this is important. Due process of law need to be followed, including the dicta of Nagraj clarified in Journal. The impugn OM is interfered to the extent the two petitions are answered in aforesaid terms and are disposal parties shall bear. So basically, our challenge constitutional validity on clause 4 was accepted, and the court in categorical terms says that since the benefit of merit cannot be deprived for the reserve because they go as a member of unreserved, the law of the country, the constitution is very clear. When they get after the 85th amendment and the 77th amendment, they are entitled to accelerated promotion and consequential seniority. And in the latest judgment by none other than our Honorable Chief Justice, V.K. Pavitsa's case, they have said it's not an additional benefit. So what I personally say is that the OM of 2002 is still in operation for the simple reason that the 78 Act is in operation. And the 2012 post-based reservation, which was brought in Assam 13 years later than in India. In the country, the post-based reservation is going on since 97. In Assam, it came in 2012 because R.K. Sabharwal categorically said that in the roster, 100-point roster, 78 posts for the general in Assam, 22 for the reserve, all fixed. 10 for the SC, STP of Assam, 7 for the SC, and 5 for the hills. So all go in their own position. Now, what has
So,
happened?
1 minute, 1 minute.
Yes.
So what has happened? All these reservations have been done away with now.
Yes, yes, I'll come to the OM. My lord, what has happened? Possibly the government, my lord, I'm coming to the offending clause. The lordship will come to the OM.
Yes, page number.
63. But I'll come to the earlier offending clause to show what they have done.
Page
Your
number.
lordship, page 63. Your lordship, this is an OM of 3rd August 2016. And this is the offending clause which was struck down in the Bhagwan Pater case, clause 4. If an occasion arises during the promotion process in which stipulated percentage in respect of reserve is met, but in the gradation list, seniority list, there are candidates of reserve who on merit is entitled to promotion, his or her case shall be considered for promotion on merit if such candidate has not gained the seniority by way of accelerated promotion earlier. So the merit part was debarred. And the judgment of Honorable the single judge categorically say you cannot do it because it's against the Constitution and Supreme Court judgment. Because throughout the country, the post-based reservation is going on without any hitch.
Just 1 minute, just 1 minute. Mr.
Yes,
Das.
Offending.
So according to you, this clause has been struck down.
This clauses has been struck down categorically. Now the Assam government possibly took a cue from order of the court where it says that the reservation policy, they can give benefit, they may not give. But it has to be under a constitutional provision. The learned single judge never says you get a license to through an OM, you overrun. Now what the Assam government has done, possibly taking a cue that the reservation is an enabling provision in Assam, it's an enforceable right. This argument was not accepted. Now what has happened?
Just a minute.
Yes, yes.
Let us try and understand
Yes,
what
yes.
is the issue because it has come for the first time. So according to you, this clause 4 in page 65,
Yes,
this particular clause has been struck down,
struck down.
or the entire OM has been struck down.
No, because the entire OMA gives the benefit of reservation in promotion.
Hmm.
But the caveat was that it did not give the concept of merit for the simple reason.
All right, so this clause 4 says that the government will consider the cases of all those candidates who are entitled for consideration under the reserve category.
Yes, because they,
Just a minute.
on merit.
After the reserve category quota is exhausted, if there are more candidates in the zone of consideration, but they belong to the reserve category, then their cases can be considered on merit, meaning thereby that at par with the general category, with a rider that they have not earlier got the benefit of accelerated seniority.
Yes.
That is the clause
Yes,
4.
that is the offending clause, which now has been struck down. Thereby,
Where is it been struck down?
no, look, 100 and, just a minute. Just a minute. Watch it, 104. Page 104, Roman 3,
Hmm.
that being the position.
No, no, Roman 3 is collection of
No,
quantifiable data.
no, page 104.
Yes. Page 104, is it you are referring to?
Yes,
Which
yes,
part-
yes.
Which part?
That Roman 3, that being the position, the court, this court unhesitantly holds. Lakshmi has got it, 104 of the judgment.
Hmm.
104. That the policy of providing reservation promotion with consequential being holding the field as per OM of 12/3/2000, the state is not within its competence and jurisdiction to deprive such service benefit to a meritorious reserve candidate, and that too without expressly waiving such policy by superseding the benefit granted under the OM.
So which is the relevant clause in OM of 12/3/2002?
Yes,
Is it a part
Yes,
of the
yes.
record?
it is a part of the record.
Yes, page number.
Page 46.
Yes. Can you please point out the relevant
Yes.
part?
I will just. Yes. The office, this is the office memorandum of 12 March 2022 in terms of the constitution provision.
Right.
Consequent upon the amendment of 16(4) of the Constitution of India by the 85th Amendment, it has been decided that the following principle of fixation of seniority of reserve versus general candidates in promotional posts shall be as follows. Can I read?
Yes, please.
SC/ST government servants shall on their promotion by virtue of rule of reservation roster be entitled to consequential seniority also, and the above decision will be effective from 17 June 1995. It was given a retrospective because that was the date when the R.K. Sabharwal judgment.
Right.
On the basis of the reserve seniority, consequentials like promotion, pay, pension shall be allowed to the concerned scheduled caste, scheduled tribe government department without areas by applying principles of no work, no pay. For this purpose, senior scheduled caste, scheduled tribe candidates may be granted promotion with effect from the date of promotion of their immediate junior, general, other backward government servants. Such promotion of scheduled caste, scheduled tribe government servant may be given with the approval of the with the approval of the appointing authority of the post to which the government servant is to be promoted at each level after following normal procedure of departmental selection committee and with approval of the APSC. Except seniority, other consequential benefits like promotion, pay, including retirement benefits for those who have already retired, allowed to general OBC government servant by virtue of implementation of the office memorandum dated 12/6/96 and or pursuance of the direction of this Assam tribunal should be protected as personal to them. The instruction contained in this department OM dated 12/6/96 stands withdrawn with effect from 12/6/96, and seniority of government servant determined in the light of the OM of 12/6/96 shall be revised as if that office memorandum never existed. Well, here I'd like to give my submission.
So,
That-
Mr. I'll hear you on every point. let us not rush into big matters because these are now subject to what you say. This 2002 memorandum appears to, is it 2002 or 12? Two.
It is 2000.
2002. This OM appears to be an effort or attempt on the part of the state to give ex post facto implementation to the amendments carried out to section 16A of the Constitution.
Yes. 16.
That those who have been
16(4).
deprived, 16(4)(4)(a), those who have been deprived of the benefits of this amendment,
Yes.
this appears to be some kind of a retroactive implementation of the constitutional provision.
Yes.
But
No, the constitutional provision was given retrospectivity.
correct,
So
correct.
actually, the Assam government will also have to give retrospectivity.
Please,
Yes.
please appreciate the query.
Yes, yes.
These are two different issues, whatever I could gather after hearing you for 10 minutes. There are two aspects. One is that the candidates belonging to the scheduled caste, scheduled tribe, etc., they are entitled to accelerated promotion and accelerated seniority,
Consequences.
provided the requisite number of vacancies within the ceiling is available. They will get it. The other part of the notification is what happens to those candidates who still remain in the zone and cannot be considered for filling up the reserve category vacancies, but they belong to the reserve category. What happens to them? That is the second aspect. So here the earlier OM said, these candidates can be considered for promotion on merit, provided their inclusion in the zone is not on the basis of an accelerated seniority granted earlier. If I've understood it correctly, that appears to be the. Now, with all respect, I don't understand
Here I
how.
beg to differ on your lordship. The OM which gives the benefit of the 2002 basically brought in an enforceable right to the reserve under the 78 Act, that the section 5 of the 78 Act talks about roster promotion and accelerated seniority comes in when 16(4)(a) was brought into the Constitution. Because earlier to it, the Supreme Court judgment in Ajit Singh 1 and 2 gave benefit of catch-up principle to the general. That catch-up principle to the general on Parliament being represented thought it that if the catch-up principle as enunciated by Ajit Singh is given effect to, the reserve will never go up to the higher post, and the concept of inadequacy of representation of the reserve will remain unfulfilled. Taking that cue, the amendments were brought in, the 77 amendment and the 85. And categorically, the Ajit Singh case was overruled.
Ajit Singh too.
Yes, the catch-up principle was overruled. That's a power which the Parliament has, the constituent power. They can remove the base. And in continuation of that provision, the Assam government immediately brought in the 2002, and your lordship will see that the earlier memorandum at page 44, which was in existence, giving catch-up benefit to the reserve general, was done away with because the last order says the order dated 12/6/96 is gone. Now, what has the government of Assam done after the judgment before implementing? What had happened? I'll have to make the facts clear because I appeared all along. The judgment was delivered on 6th of June, and immediately I prayed for implementation of the order because in the meantime the private respondents approached the division bench. The division bench did not admit the appeal and no interim order was passed. So under the law, the finale
Appeal against this order.
Yes, the judgment of the
That has been dismissed.
not dismissed. It has not been admitted. Notice has been issued where I put in objection. So the division bench refused to pass interim orders, and the Assam government did not go on appeal. It is pending. Now, at this stage, what happened? They should have implemented the order, but the parties, the general, they argued that this matter should be placed before the larger bench. They have a right. And this was heard in the month of December 15, and Honorable Justice Jameen, the matter was CAV'd, and we are awaiting an order on the second count. So basically, since it's a coordinate bench, as soon as he passes whatever order to refer to the larger bench or dismiss the contention of the general, I go on for implementation. It is at this stage that an 18 OM comes and not only has it again brought in clause 4, I come to that offending. It has brought in catch-up principle. My lord, we never envisages, constitution never envisages an OM to override a judicial order. The judicial order inter partes is binding, finality is there, subject to appeal. Now the Assam government, since they all along has been opposing the petition of Bhagwan Patter, they took a stand shortcut. They thought that possibly the learned single judge has given a paragraph where it says it's an enabling provision. You can give, you might not give. Well, you can give. First of all, you don't implement the order. You may not give. In the process, it overrides the judicial order. Well, again, a principle of constitution which is nowhere in India, we brought in again in clause 4. Well, the clause is the same. A lot of people come to the offending. Page 107. Well, what was? Well, it's an abuse of the process. It's a fraud on power. The Lordship will come to page 108, which is the relevant paragraph.
Yes,
If I may read.
yes, please.
This is the new clause 4A. In case of promotion in Group A service, the quantum of reservation for SC, STP, STH in promotion shall be as per stipulated percentage of reservation available for these categories. However, SC or STP or H, government servant in class Group A services on their accelerated promotion by virtue of rule of reservation shall not be entitled to consequential seniority. May see, it's a blatant encroachment on the power of finality of a learned single judge. Blatant, brazen, what more is required? They say will not give you. The application of general catch-up principle will now allow eligible officers who were senior in the merit list at the entry level in Group A services to regain their seniority in the promotional post once they are promoted to the same cadre as an officer of reserve category, provided the officer of the reserve category had got his promotion ahead of an officer senior to him in the merit list by way of accelerated promotion on account of reservation in promotion in a particular cadre. Seniority of government servant in Group A shall be revised accordingly as per the above. It is directly in contravention of the single judge's order. Further, an officer promoted from B to A shall also regain his seniority. Well, who will regain? They have not specified. I will specify the general, because the catch-up principle, the general takes over as per Ajit Singh 1 and 2, which has been overruled by the 85th Amendment. They are bringing everything. On promotion, reserve is his compatriot means we, in Group B service, provided that the officer was senior to the reserve officer in the particular grade B cadre prior to the promotion of the reserve officer into Group A. Seniority of such B servant promoted to Group A shall be revised accordingly in Group A. Well, they have categorized. This is the part, the sub-clause. Same clause 4 brought in. If an occasion arises during the promotion process in Group A service in which stipulated percentage in respect of reserve is met in the next promotional grade, but in the zone of consideration, there are candidates of reserve category who on merit are entitled to promotion, their case shall be considered for promotion on merit. This is important, comma, if such candidate has not come into the zone of consideration by way of any accelerated promotion earlier by virtue of rule of reservation. So the same offending clause brought in, but what more is required? Who has given
That clause has not been struck down by the
it
court.
has been struck down because
Where is it?
the
Where is-
clause,
where-
hold on, just now I have already said 104, because the on
Acha-
merit they
Acha,
cannot.
according to you, this observation made in Roman 3,
Yes.
that amounts to striking out down of
Yes,
that clause. only.
Yes,
That is your
because-
submission.
yes, because the learned single judge was convinced, Lordship has gone to the judgment. My argument is that you allow me to go get the benefit of 16(4)(a)(b) to the top. When the selection post comes in, you put a spanner that you have a birthmark. What is the birthmark? You got it earlier. You will not now get. So on merit, why will I not get? Because when I go on merit, I go as a member of the unreserved.
No, no, they're not depriving you of on merit.
They are depriving us on merit. That is the reason. So only the cases have come up. In fact, now what has happened, all seniority position in the higher cadre, my clients who have got all the benefit have reached the top. Lordship knows that we leapfrog and we go at an earlier point of time to the general because that's the law. Parliament will take a call. Now, when in the selection post, I'm at number one, all selection, the earlier round of litigation from one gradation, they bring us down. By applying this, that you will not be selected now. You came by accelerated promotion. And that was the genesis of all the case. And
But how do you know you will not be selected?
well, the
How
fact,
do you-
the
how do
fact
you-
that all promotions for two years has not been all stopped because in the roster, the Supreme Court has categorically said, if the roster issue comes in, you cannot give promotion at any level. Now the general are also suffering and we are, because what had happened, the Pator case clearly laid down that this is the law we follow. Because the learned single
So
judge.
now you want that the court should pass an order implementing this.
No, I don't want. What I want that this, if this offending clause and OM is given effect to at this stage, the judgment which is already in operation is awaiting not final orders, whether it will be referred to the larger bench. The division bench has not interfered, stating thereby meaning that the single judge's order is there. Now in Assam, the selection process has already started. That is my case. I have been brought down. Your Lordship will find that I am a superintendent engineer. I was on top of the list. I've been brought down on the ground that the clause 18 again brings in the 16 clause 4. So again, I lose out. So it is at this stage I come to this court on one ground that judicial order has been encroached and inter partes binding orders of a court, unless overturned in an appeal. Now what will happen? They will go ahead with the selection. So I'm praying for an interim order because if interim order is not there, directly there will be clash. The government will proceed with this and my implementation of the judgment, which has not been interfered by the division bench, will be stuck.
No, not interfered is not the correct submission. The matter is pending. before
Yes,
the larger
that
bench.
has been. but at this stage-
Yesterday, my learned friend has taken time.
Malad,
That appeal was there yesterday.
Malad, that one of the appeal had come not time, it was some steps were required, not time. Malad, I didn't take time. So it's whether it was taken time or not, that has nothing to do with
That's all
this
right,
case.
that's all right. No, that's a different thing.
So
What I am
I
saying
pray,
is,
if your lordship,
this judgment has not attained finality.
if this judgment has not attained finality, it has attained finality because only the implementation was stalled. Now this OM comes in and it basically brings in the earlier notification. As a result, the chaos will be what will happen to the selection now. Because now the government.
No, that is another matter.
Yes.
We are
So
inquiring
what
whether
I
there
want,
is a.
this matter needs to be heard. Every council needs to be heard, state has to be heard. Well, I pray that let this matter be fixed on a expeditious as fast as possible, but an interim protection that no promotion should now be affected on this, because now the government of Assam will have to implement because my petitions are waiting for implementation. In fact, one implementation has already happened and that was not given, and yesterday contempt proceeding was also done. Now this chaos will be there.
Contempt proceeding against which
Against
order?
all the commissioners of a department
Again, for violation of which order?
for violation of non-implementation of a promotion order which has got its genesis from this. Clause 4 was implemented. So yesterday contempt was there. So what I pray, I want this matter to, because it's an issue of great importance.
No, in this order, Mr. Das,
Yeah.
these queries are just to understand. the
Yes,
case.
Lordship.
This judgment dated 6/6.
Yes.
What is the operative part of this
The
judgment?
operative part of the judgment is at paragraph 3 and it's summarized thereafter. The 104-page operative part at Roman 3, the learned single judge on by submission of the law of the country convinced that since the 78
The
Act,
question is, what is the operative part?
the operative part is the Roman 3, the clause 4 part,
Yes.
that they will be entitled to merit. Thereby the
Where is that? Where is that? Please read it out.
well, theirs being the position this court unhesitatingly holds that the policy of providing reservation with consequential seniority being holding the field as per OM of 2002. That's the reason I came to the
So
court.
reservation with consequential seniority will be given to those who come in within the zone.
Yes.
But what about the candidates who are considered on merit? It is in only in their cases the clarification of clause.
Yes, because
four.
the learned.
Your client comes into the zone as a
On-
against the reserve vacancy or on merit.
On merit. No.
Then he
on
cannot get
merit.
accelerated.
Mullah,
He comes in on merit.
Mullah, I'm not, how can I claim accelerated seniority when I come on merit? When I come on merit, only my next question is how I compete and get it. Because my earlier consequences.
So
Yes.
that's
Yes,
what we ask.
Yes.
Your client is now aspiring to or claims a right to be considered for promotion to the next higher post of, which is it, additional chief engineer.
Additionally, chief engineer.
Right.
And the
He's a-
bar is clause 4.
He's a superintendent engineer at
Yes,
the
yes.
moment. In which department is this?
It's in the water resources.
Water resources. So you say he is in serial number 1 in the seniority list.
No,
Is
no,
that
I don't
correct?
say, I say why, because the selection has not, the gradation list has been prepared in terms of the new OM of 18. So
Where is
say-
the gradation list?
Yes, it is there. Lordship will find at 110. The governor of Assam is pleased to publish the provisional gradation
Yes.
in the cadre of superintendent engineer under water resources department for the year 2022 as per statement enclosed for information. The Lordship will find Rudreswar Lanfasa, he is at 11.
Hmm.
The third column is important. He comes to the cadre of superintendent engineer
Hmm.
on 2/6/2018. Then your Lordship will come to page 116.
So are you agree
This is-
with the seniority position?
No, my anxiety is that,
No. Mr.
yes, I'm totally
Please give
agree.
the answer, then
Yes,
you
I'm
make your
agree.
arguments.
Yes, I'm agreeing.
You are agreed.
Yes.
Is it under challenge?
Mullah, this is under,
This is the present one.
this is the present one which is under challenge.
Is it under challenge?
Which one?
This seniority gradation list,
This gradation list, I'm the agreed person, so I'm.
is it under challenge?
Yes, it is under challenge.
So is there a prayer to set it aside?
Yes, it is okay. For passing of just with the consequential order should not be passed in terms of the OM. There is a specific prayer,
Is there a prayer to set aside the gradation list? It is there.
43, 40,
Copy of the writ petition is not with me.
43. 39 is there. Yes, it is at page 39. Lordship. Consequential seniority, starting out the clauses issued by the Department of Personnel and consequential final gradation list, because I lose out in it.
So you, according to you, you have been made junior to which
Yes.
respondents? Who are they? Are they parties in this?
No, they are not parties, but because the selection, I have come at a stage when contemplated action selection of those persons who are junior to me, they have been brought up in the final gradation.
Who are those persons?
But they are at page 117.
No, are they respondents in this
No.
petition? They are not respondents. So
Because
therefore-
I make a specific environment, on this, they will precipitate a selection. Selection has not happened because they have corrected the seniority in terms of the clause 4, which was again struck down by.
No, that's all right, Mr. Das. You are essentially challenging the gradation because you say that by operation of some OM or some law,
Somehow in this way.
all right, your position has been brought down,
Yes,
correct?
and I foresee that I will be not.
So if you succeed in the writ petition, your seniority position will have to be counted above some others. Is that correct? Is
No,
it not?
now, because
Not now.
I am seeking an interim protection of the OM now. I cannot ask for because the selection is not. Only I am bringing that they have precipitated
No,
the selection.
selection is something which will
The
happen later.
selection will, consequential order is the selection in first.
What about the gradation list?
Yes, this gradation list is sought to be corrected on the basis of an OM of 18. I want a suspension of the OM because the OM is now will put up a total, there will be a total chaos because already I want the benefits of the judgment that has not been done. In all cases, all cases are pending. Say, for
Das,
since past 3 years.
we'll hear them, but
Yes,
you need to, OM applies in REM.
Yes, my lord, and the OM applies in.
You say that you want some relief for your client, we can consider. But why should we suspend the OM in REM only because
No,
your
no, no,
client?
I will not, well, if the selection process is stalled, then the OM in REM, I cannot have that prayer, the government have to be heard. Naturally, because this is, because now if your lordship doesn't pass an interim order, now as soon as
No, no,
the,
interim order, we will pass if the facts justify, otherwise we will not pass.
yes,
Therefore, the queries.
yes,
Interim order is, obviously, you know, with your experience,
yes.
expertise. These are matters where interim orders will be passed when the facts justify.
yes,
That is the reason these queries are being made. If you are aggrieved that
I may agree,
your position has been downgraded,
downgrade.
then should you not implicate those persons over whom you are claiming seniority?
Malad, at this stage, these, I have already averred that, first of all.
So
the
according to you,
selection-
they are not required to make parties.
No, they will be made parties only when, as soon as the selection is held. The selection is held, and I cannot make them a party at a stage where the selection is not held. And the 226 power is, they get precipitated action, interim protections can be given. It's too wide a power because you protect the fundamental and legal rights.
That's what we
It
say.
is at
It
this
is
stage
not
that-
about the power of the court. It is about whether this is a fit case to exercise the power.
Well, if, well, what more can I show? I show that a prejudice has been caused to me because of an impugn OM.
So you please implicate those persons over whom you are claiming seniority. In that case, we can consider your
Yeah,
claim.
as
Otherwise,
per-
it is difficult.
Yes, but your lordship, if your lordship, I'll definitely include it. There is no. This was a query which your lordship has rightly asked, and this has been answered in my averment, where I say that I can't make them because the selection is not held. I precipitate, since the earlier clause has been brought in, they are going to hold it. So what I pray, I will correct it, lordship, immediately I'll correct it. The lordship will give you the interim protection. That
We'll see what they say and then
That's-
we'll pass.
that
it.
is the, that's fine.
My lord, I have instructions to appear on
What?
behalf of serial number 4, Rajiv Goswami, in that impugned seniority list.
But they are not parties.
They have not been made parties, but they will be affected even the adverse order is
That's
passed.
what there is. Mr. Das is
I
still
don't,
not.
my lord, in fact, it will be bad for non-joinder of necessary party. That Udit Narayan's case, my lord, then the petition is liable to be dismissed on this count. When he has a
But,
prayer.
Then he
And
is
my
not,
lord,
he is
let-
not willing to, so we'll have to go by the law then what. to
Yes,
do. Technicalities are there.
page 923, my lord, Udit Narayan.
So, Mr. Chaudhary, should we first get the views of the government and then we'll
Yes.
come back to you?
Yes, certainly, my lord.
That clear option.
Yes.
And my first submission will be the retribution itself is not maintainable. For the simple reason that the judgment on which they are placing reliance to say that the government has gone beyond the judgment passed by some court, but specifically by one of this is A.D. Chaudhary in Bhavan Pasas case. Lordship may just have a look. They thought that that judgment is actually favoring them. It is not. That judgment has given the liberty to this, to the government to frame policy, pass appropriate order, which we have done. And unfortunately, they did not challenge it. Lordship may straightway turn to page 105 of the writ petition. 105 of the got number
10?
5.
That's what I was trying to figure out,
My lord,
what
I'm-
this judgment actually.
I mean, making specific submission. And they are relying on the fact that pursuant to their promotion to reservation, they automatically get the benefit of constitutionality. Contrary to the other theory of catch-up theory. This was their submission. And for that, they relied on an OM of 2002. Honorable Justice A.D. Chaudhary in his judgment said that the 2002 OM is holding the field. True. But then there is a rider. A rider is available at page 105. Let me kindly have a look at Roman 9. Article 16.4a and 16.4b being enabling provisions The state is at liberty to implement its policy of giving reservation in promotion with consequentiality, 1. Number 2, at liberty to provide for reservation in promotion without consequentiality. And number 3, at liberty not to provide any reservation in promotion. It is in, and the OM, Roshan, kindly have a look at this OM, present OM on the challenge.
Yes.
Let's start, yes, page 107.
Yes.
Page 107. The opening words are like this, my lord. The Honorable Guwahati High Court in its judgment and order it is 6/6/2022 in WPC number so Bhagwan Pata, equality for two judgments, my lord. At para 7-9, which I have just now read, my lord, has observed that the same para has been quoted. And thereafter it has provided for catch-up. There is a balance. Lordship knows that in Indrasuni judgment, the Honorable Supreme Court.
But Mr. Majumdar,
Right.
with all respect to the London single judge,
Right.
Mr. Coordinator, is the government agreeing with this observation or just finding it convenient?
My lord, we have not
Has
filed
the state has the liberty not to provide reservation in promotion matters? Where is that liberty?
My lord.
Does the state have the liberty not to provide promotion in reservation in
No, I'm
promotion?
not a promotion, my lord.
No, what I'm asking
My-
you is the state
My lord.
actually in agreement with this observation or it's just taking advantage of some observation in a
Well,
judgment? Where, do you really have the liberty not to provide promotion, reservation in promotion?
No, our policy is, madam, this policy, it is very clear, Roshni, kindly see down below. The first paragraph says, policy of reservation and promotion shall continue. We are continuing with the policy of reservation. and
Therefore,
promotion.
it is not that the state has the option not to provide
My lord,
reservation
as,
in
my
promotion.
lord, as per the constitutional provisions of Article 16 for two amendments, the 77th amendment and 85th amendment. 77th amendment came immediately after this Indrasoni. Because Indrasoni said that reservation will be only in the matter of initial recruitment and not in promotion. That is why this government was compelled to provide for reservation in promotion by a specific law and made the amendment in the constitution to enable the government to adopt a policy, pursuant to which we have adopted the policy of reservation in promotion.
Right.
Now, the second is whether we'll go ahead with the consequences or catch-up theory. My learned friend has made a specific submission which he often makes. He says, with the second amendment, that is 85th amendment, consequential seniority is automatic. It is not. And I've brought the judgments to show that Honorable Supreme Court has made it very clear. These are only jurisprudentially developed concepts of service jurisprudence developed by judicial precedents, consequential seniority and catch-up theory. And it is if the state does not make a policy of consequential seniority, catch-up theories automatic, which my learned friend doesn't agree. Judgments are very clear. I just refer to that. As a result, my lord, there are two things. One is reservation promotion, and second is after reservation being given to the reserve category promotees, whether catch-up theory will be followed, meaning thereby that after the seniors in the feeder cadre get subsequently promoted, whether they will regain their seniority or not. If catch-up theory is followed, they will regain. If consequential seniority is followed, then seniority on the reserve category promotees on their promotion, they gain the seniority and then they get the seniority of promotion as well as seniority.
So at the moment, does it come under the zone of consideration?
Well, I am not on the facts of this case. I am first saying that this writ petition will not be maintainable unless they challenge this liberty given to us. Lordship will kindly appreciate this paragraph is absolutely clear. It says at liberty to provide for reservation promotion without consequential seniority. So if we have not provided consequential seniority to a particular category, which my landlord is saying.
Yeah, but when the judgment is under appeal and pending before a larger bench, what was
Well,
the?
judgment is under appeal by both the categories of persons. People who have challenged the OM, very OM, providing for reservation promotion, they have also challenged because their contention was rejected by the almost single judge.
So what was the tearing hurry for the government to issue this notification?
My lord, my submission with your lordship is the objections they are raising about the present notification is totally in consonance with the judgment passed by Honorable Justice A.D. Chaudhary. That being the position, unless they because in the writ petition, Lordship will kindly see what is their pleading. I have just now read, my lord.
Yes.
Paragraph 21 of their writ petition at page 25, Lordship may kindly see. They were under the impression that there is no liberty, the theory of constitutionality is automatic, but it is not. My lord may kindly see para 25, para 21 at page 25. That recently the Department of Personal Government of Assam by dated 18/1/2023 has issued another office memorandum in total violation of the not only the constitutional provisions envisaged under Article 14 and 16(4)(a), 16(4)(b) of the Constitution of India, Assam Scheduled Caste and Scheduled Tribe Reservation of Vacancies in Service and Posts Act 1978 Amendment in 2012, but also against the judgment rendered by the Honorable Supreme Court in M. Nagaraj, Jarnal Singh 1, Jarnal Singh 2, Saurabh Yadav, as well as later judgment rendered by the Guwahati High Court in Bhagwan Patar. The said action clearly is an encroachment on judicial power of finality rendered by the Honorable Guwahati High Court, in as much as binding judicial judgment rendered in Bhagwan Patar's case between inter parties is sought to be overruled by the executive governor, thereby affecting valuable enforceable rights. This is their submission. Just the previous paragraph, my lord, para 20 at page 24, just last sentence, may kindly see. 3 lines above from the bottom, my lord. Para 20. And the matters are pending adjudication. It is pertinent to mention herein that in neither of the aforesaid cases, no stay order has been granted against the operation of the judgment dated so passed in Bhagwan Patar. So they were under the impression that Bhagwan Patar judgment has given the full relief, and now the present order will be in this present judgment is against Bhagwan Patar. No, Bhagwan Patar judgment, on the one hand, my lord, your lordship is absolutely correct, my lord. I have got some reservation, my lord, about passing comments on the judgment passed by the Honorable Justice.
No question of, but then we can.
Lordship is maybe correct, but the fact remains that when the petitioner comes to your lordship, making a complaint about some order passed by the government, they will have to first of all say they were party in that case. Bhagwan Patar is his client. He represented. Now, in his case, when the Honorable Justice A.D. Chaudhary has given
He is playing a role of a counsel.
No, I'm talking about the Patar. I'm talking about the petitioner, my lord. Petitioner was the party. In his case, this Honorable Court has given a liberty. On the one hand, it has been held that OM of 2002 holds the field, but on the other,
just 1 minute. The present petitioner,
my lord,
was he the petitioner
he is the petitioner.
in the earlier round?
Same petitioner, my lord.
No. Malad, possibly I'll have to
Let's get the facts correct.
He is not the same person. He was not Bhagwan Patar, only the name.
Anyway, my lord.
Earlier it was God, it is
1 minute.
Radheshwar Lankhasa. He's not a part.
My lord.
In fact.
Yes, my lord. I'm sorry, my lord. He is not a petitioner. But I'm sorry. What I'm saying is, my lord, and the persons who were taking help of the constitutionality theory, same person has filed a petition, my learned friend represented, and he knows as far as counsel is concerned.
So is it the, Mr. Majumdar, some facts, give us the facts, then you go on arguing for the whole day. Is it the first time the petitioner has approached this court, or he was a petitioner in earlier round also?
For the first time.
He said, I'll just clarify.
A simple question.
Yes, a simple question will be answered.
What is the answer? What is the answer?
This is the first time I have come.
Yes.
You have come for the
And
first time.
Bhagwan Patar, I want to correct the learned additional advocate general. Learned Bhagwan Patar never challenged this. He challenged the constitutional.
All right. I'm sorry, man. I'm to the extent I'm sorry.
And another thing I like to place.
No. Let me argue. Let me complete my argument. That answer, your lordship, he has given an answer.
Yes, I'll give a reply to him.
You will get an opportunity.
Yes, definitely. He has a right.
My lord, my submission before your lordship is today's order, the notification impugned by, as your lordship has said, it is an order in rank. It will have a, my lord, huge ramification once a stay order is passed on this statement. Because this OM has been issued specifically in consonance of the judgment passed by Honorable Justice A.D. Chaudhary. Unless anybody is agreed by that, unless he challenges it, he cannot challenge this. He has to challenge that judgment first. This pure, and it starts, OM starts with that finding that we have been given a liberty, and based on that liberty, we are passing this order.
Now, Mr. Majumdar, supposing the full bench, which is hearing appeals against the judgment dated 6/6/2020, is it correct?
Division bench is.
Division
yes.
bench is hearing.
Yes.
State has not gone on it.
Just a minute. Supposing the division bench interferes with the judgment of the single judge,
My lord.
then you will have to recall the OM. That you agree? Just give an answer to that. Let's figure out what are the facts.
Yes,
You will have to recall.
possibly.
Yes or not? Because you made it very clear that this OM is only in accordance with the judgment dated
Yes,
6.
yes.
Supposing it is interfered with,
My lord.
you will have to recall.
Naturally, we'll have
What
to pass it
happens to the
control.
promotions given in terms of the OM then?
My lord,
You
as
give us
on,
an answer.
my
on
lord,
that.
as on today, my learned friend himself has pleaded specifically that there is no stay there. So editorial judgment will prevail till it is interfered
So
with.
therefore, if the judgment is set aside,
My lord.
the government will be bound to withdraw the OM. Obviously, because yes or
Or
no,
we'll have to modify, my lord.
whatever you
My
have to.
lord.
So this OM at the moment
My lord.
obviously has been issued in a hurry. Then the government doesn't do it normally, but let's grant it to the government for now. What happens to the consequential decisions taken in the meantime? What is the law? Can you sustain it?
My lord, my submission will be like this, my lord.
Hmm.
My learned friend is arguing for the purpose of saying that consequential seniority should prevail.
Okay.
And Lord will kindly appreciate one thing. There are two theories, my lord. One is consequential seniority, other one is catch-up theory.
No, but
Now-
the problem is, Mr. Majumdar, when the court makes a query,
My lord,
the
I'm
answer
sorry.
should
I'm
come.
sorry.
Then you can make
I'm
your
sorry,
submission.
I'm sorry, my lord.
As I have
I'll
indicated,
hear,
I am
well, I'll
open-
hear your lordship question once again.
I am open to hearing arguments
I'm
as
excused.
long as you are not satisfied that you have placed it.
I'm sorry.
But when a query
My lord.
comes, the answer has to be
My
there.
lord,
What will happen to the consequential decisions then? If the judgment is overturned, you will be bound to recall the OM.
my lord.
And if you recall the OM, what happens to the consequential actions taken in the meantime? Give us an answer on
My
that.
lord, I'm giving the answer. My lord,
Because it is not that nobody has challenged this judgment.
My lord, it is.
Somebody has challenged this judgment. It is under appeal. The government is aware of it.
My lord, I understand your lordship question. What your lordship is saying is, if today consequential seniority is followed and he is not given the benefit, what will happen in future? Now, but in the present case, there
If he is not given, means somebody is given.
yes, now
Yes.
now the contra situation here is, it is not a case where if this judgment is not followed, this OM is not pursued, nothing will happen. It will. Now, if this OM is not followed, and what he is saying is to be followed, petitioner, I'm meaning, my lord, then the catch-up theory will have to be consequential.
Mr. Majumdar, although
One party will.
I
either
must
way
say
be
that I am
affected.
not convinced with the case projected by the petitioner. But at the same time, it cannot be denied.
My lord.
There are few things are happening which normally doesn't happen. And when an appeal is pending, if you want to implement this OM, at least you have to take the leave of the division bench. Otherwise, you can't.
My lord, my submission here.
What
is,
will
my
be your stand? You take the
No.
instruction, we'll take it up at 2. Either we stall it or you give an undertaking that before taking further action in the matter, you will obtain the leave of the division bench because the appeal is pending.
No, my lord, lordship.
Otherwise, it will be
My lord,
difficult.
Possibly, I have not been able to convey.
Hmm.
It is not a case where this situation will arise.
Why is that?
The reason is very simple. If there is no stay in the division bench, my lord,
Hmm.
till now there is no stay,
Hmm.
then the editorial judgment will prevail. Editorial judgment will prevail. Now, at the same time, Honorable Justice editorial has given a liberty that you take a policy decision. Since there is no stay, we have.
When is the appeal fixed?
Next week it's coming.
It has been coming, but.
No,
the
next
lordship
week,
knows.
in fact, one thing I like to add, a very important pertinent question your lordship has put in, I should answer. My learned friend has just now
Mr.
said,
Majumdar is not finished here.
I have not finished.
Haven't finished?
then I'll have to.
So, my lord, here is a case where we will have to follow either catch-up theory or consequential seniority.
We are not even concerned with that.
My lord,
You will have to tell us how will you undo the doings
my lord.
if the division bench allows the appeal. Unless you say that, we will have to think of some manner. We can't allow these things to happen.
My lord, in
There is
the-
something called propriety also. In how many cases you find the government implementing a court order, purportedly implementing a court order, even when an appeal is pending and is fixed for hearing? Are we to understand that there is nothing in between?
my lord.
So whether he makes out a case,
My lord.
prima facie, I'm not convinced with that case. But then What is happening? What is happening? It can't go unprotected. It has to be subject to further orders passed in the writ appeal.
That we also always, as your lordship is indicating, always be
So
subject to.
are you not
Even
required to take leave?
whatever action they take, that will always be subject to final.
Before taking any action, you have to take the leave of the writ appellate court. That will provide, unless you give yourself that assurance.
My lord,
No, that will be difficult, Mr. Majumdar. You can obtain instruction and come back at 2 if you want. That will be difficult.
there's a holiday today.
Hmm?
Today is a holiday.
Then we go by whatever transpires in the court proceeding. Something is amiss. What to do?
Well, my
I agree with you that the OM cannot be stayed and we will not stay it.
yes,
But then what happens to the consequential decision? Your entire basis of the OM is the judgment dated 6/6/2022.
yes, yeah.
If that judgment goes,
Right.
you will have to undo everything you have done.
Yes, ma'am.
That assurance you have to give us.
That
Otherwise, that will be the order.
my lord, that is an accepted position, my lord. Even
Then should we record your submission?
even if we do not give any assurance, tomorrow if the judgment is set aside, naturally this present OM which is issued in pursuance of the judgment will have to be modified, my lord. This is quite natural consequence, my lord.
Then what is the harm in recording that this is your submission? If it is so natural,
No, my lord.
natural things should happen naturally.
Well, should. But then what will happen in the division bench, I don't know, my lord. It may,
Now you can continue and make your arguments both sides. Now you can say whatever you want, whatever submissions you want. We are only on the interim,
my lord.
only on the question of what is the interim.
But
that can
interim
be
again,
passed.
as your lordship has already seen.
The OM will not be stayed. Question doesn't.
Yes,
arise.
if that is so, my lord, then so far as the gradation list, etc. is concerned,
Hmm.
private parties will be.
Choose
affected
between
there,
two.
my lord.
Either give an assurance that till disposal of writ appeal,
My lord.
no consequential action insofar as this department is concerned will be taken for promotion. Or will pass an order that you seek leave of the writ appellate court and then only proceed for this department.
No,
Between
my
these two, which you want to choose,
lord, if-
we'll give that liberty to the
No,
government.
if in the division bench, my lord,
Hmm.
a contrary order is passed,
Hmm.
naturally, my lord, everything will have to be changed.
All right. All right, yes.
I'll counter on one point.
There's nothing else to counter, Mr.
Malad,
Mr. Das, you can argue, but you have not been able to make out a case on facts. Only thing we'll see is how, because the manner in which things are being done, the court cannot remain a silent spectator. That is the only reason we are thinking of. Otherwise, there is no case made out here.
Malad, insofar as the lordship has already come to a finding regarding the constitutional validity, there is no case.
Where?
Then the lordship will have to record a.
No, interim, for interim. We'll record the finding.
The interim order, Malad, one thing I like to say, the Assam government just now said that we will bring in the catch-up principles. Then at 2 o'clock, let the chief secretary, the personnel secretary says that why this OM was, catch-up principle was withdrawn. Two things he cannot say. Then a responsible officer of the court, additional advocate general just now made a submission. We brought in the catch-up principle because we were given liberty by the learned single judge, which I countered. Then your lordship will come to page 46. Lordship, if your lordship comes to page 46, the Assam government has already withdrawn the catch-up principle. From the thin air, how did it come in this OM? That's my case. Lordship will come in at the last portion of the OM dated 12th of March 2002, page 46.
Yes.
Except seniority, other consequential benefits like promotion, pay, including retirement benefits in respect of those who are already retired allowed to general OBC by virtue of implementation of the office memorandum dated 12/6/96. That's the catch-up. And or in pursuance of the direction of the Assam Administrative Tribunal Court should be protected as personnel to them. The instruction contained in this department office memorandum dated 12/6/96 stands withdrawn with effect from 12/6/96. It itself and seniority of government servant determined in the light of the office memorandum will be revised as if that memorandum has never existed. issued. Well, this is the government's categorical stand. There is no catch-up principle after the 77 and the 85th Amendment. And this has been holding a field. Today, my learned friend is saying that we will bring in the catch-up principle because liberty was given by the learned single judge. But I will show that no liberty was given. Liberty was given that you can bring or you can change, but it has to be Nagraj and journal compliant. And my entire case was based on journal and Nagraj. So that is my case. So virtually the learned single judge gave a finding in my favor in terms of the Supreme Court decision. So the learned single judge rightly said that you can change the policy, but if you do it, you kindly do it.
Your favor means you as an individual or the
as
petitioner?
as a class, because I'm representing the officer, the reserve class. Because the two classes are there in India, the reserve and the general. That's how the judgments are flowing from 1950. So the petitioners, the learned single judge has never said that you abrogate the journal and Nagraj and change the policy and give them catch-up principle. Well, the Assam government
No,
cannot
that
do.
the learned single judge cannot say. How can a high court say
Yes.
that?
No.
Overthrow a Supreme Court judgment?
Why is the Assam government at 2 o'clock? Why did doesn't come with a clarification from the chief secretary that we have withdrawn catch-up principle? They say that this OM was withdrawn in 2002. Today, suddenly in the OM of 18, they said catch-up principle will bring.
Acha, Mr. Chaudhary,
Yes.
though your client is not a party, you want to make some
Yes,
argument on
yes,
law?
otherwise, my lord, because in the other case, we also contested the proceedings. my lord.
Right.
Also, will kindly give me 10 minutes time. I'll put the things in perspective.
Yes, but have you been briefed on the query of the court?
Yes, yes.
The query is, let
Yes.
me place it again. On merits, we will say we have just indicated in mind that because it is essentially a dispute of seniority. He comes into the zone if his seniority.
In
is
fact,
there.
it's a seniority dispute, nothing else.
It's a seniority dispute and he
Yes.
has not implicated the persons over whom he's.
Yes,
So prima facie, this petition is not maintainable.
yes,
But what also cannot be denied is this is a writ petition. You see, the single judge has passed a judgment. The OM of 18th of January is entirely on the single judge's judgment.
yes.
Correct.
Yes,
In fact, it starts with the quotation of the paragraph.
yes.
Now, the government is aware that this judgment is under appeal. Whoever has filed appeal is not relevant. The judgment is under appeal. The court is in the process of hearing the matter. So obviously, the single judge's judgment has not attained finality. Right? There can be no debate on that. Merely because there is no stay order. The government has issued this OM. This OM is in purported compliance with the single judge's order. Tomorrow, if the appeal is allowed, and in the meantime, the government takes consequential steps, not only in his case, but in any other case, and the situation is reversed, how will they undo the things? On
No, my
what
lord,
basis?
if the appeal is allowed
Mhm.
and what the government has done now, these are consistent. There will be no inconsistency. Only if the writ appeal is dismissed,
Mhm.
then only, my lord, what your lordship is, conceiving will take place. If writ appeal is allowed,
Mhm.
then what the government has done is absolutely consistent.
But the government says it is in favor, it is in
No,
accordance with.
That's why, my lord, let me place the things. I'll just take 10 minutes time, my lord.
Mhm.
Now, my lord, in the writ petition which was decided by the learned single judge, two aspects were rather failed for consideration. One aspect is regarding quantifiable data and all, and other aspect was whether consequential seniority concept is relevant in the context of the state of Assam or not. Everything boiled down to that. Now, my lordship knows, after the constitution amendments, all the constitutional amendments were challenged before the Supreme Court in Nagraj. In Nagraj, Honorable Supreme Court said that Article 16(4)(a) is an enabling provision. In pursuance of the enabling provision, a state may make provision for reservation in promotion and also consequential seniority. My lord, these are not automatic. Merely because there is reservation in promotion, that does not entail consequential seniority as a matter of course. Now, as far as state of Assam is concerned, my lord, under the old 78 Act, after the constitution amendment, 12/3/2000 2 notification was issued, whereby an earlier 1996 notification was reversed, and it was said that reserve category candidate on their promotion by virtue of roster will also be entitled to consequential seniority. That means as a principle was never in application following that 12/3/2002 notification. My lord, post Nagras, which is my lord 2006, then my lord, the entire dimension of this, my lord, reservation law changed. Here, my lord, the Nagras brought in 3 aspects. That to apply reservation, first you will have to have data to find out whether this particular class is backward. Number 2, whether this particular backward class is adequately represented. Third determination was if reservation is resorted to, whether it will compromise with the efficiency in administration. That position was slightly altered in Jarnail Singh when Honorable Supreme Court said that since these classes are already included in the SC/ST list, therefore there is no further requirement of collection of data for determining whether they're backward. Because they're backward, therefore their name finds place in the 2 list. Therefore, there is no necessity. However, the other 2 continues. I mean, look, in this scenario, there were several litigations before the Supreme Court. I mean, Lord, some of them are, for example, my lord, UP Power Corporation, then my lord Paneer Silvam, then Pavitara, Jarnail Singh, Mukesh Kumar, and all these cases. Now, eventually, the reservation law boils down to it's an enabling provision. A state may make provision for reservation in promotion, as well as, my lord, consequential seniority, or in a given case, a state may say, we'll have reservation in promotion, but will not give consequential seniority. No reserve category candidate can come before the court and say, I'm aggrieved, because it's a policy. Because Supreme Court said it's an enabling provision. Now let us come to the Assam. That's the All India perspective. As far as Assam is concerned, my lord, 1978 Act was amended in 2012. Basic purpose was, my lord, earlier the roster was adopted against vacancy. It was not post-based roster. Because in R.K. Sabharwal's case, Supreme Court amongst others said 2 important things. One is post-based roster, other is a reserve category candidate, if he gets on his own merit, then he is not to be counted. And thirdly, my lord, the roster point will stop the moment the reserve category post points are, rosters are filled up. Now, my lord, in 2012, post-based roster was incorporated. Provision for reservation in promotion was made, but consequential seniority was not provided. Then, my lord, 2 OMs came after 12/3/2002. My learned friends would have pointed out that. One is 29/12/14, other is 3/8/16. In both these notifications, it is said that seniority, reserve category candidate who has earned promotion by virtue of roster will not get seniority. Therefore, the issue before the learned single judge in the last round of litigation is whether the state can, when 12/3/2002 is still holding the field, because the state has not expressly passed any order, therefore 12/3/2002 continues. Now, pursuant to the judgment of the Honorable Court, the learned state government has expressly passed an order. So, what is wrong in it, my lord? He cannot seek a mandamus. Please come to this Mukesh Kumar judgment, my lord. In Mukesh Kumar, Honorable Supreme Court has said, you cannot have any grievance if the state decides not to have, 2023 SCC page 1. My lord, if a state decides will not make provision for reservation in promotion, a reserve category candidate cannot have any grievance. If a state makes a provision that will not provide consequential seniority, a reserve category candidate cannot have grievance. That's the law of the land. Now, my lord, my learned friend was making a submission regarding that clause 4 of that 2016, which according to him has been overruled by the learned single judge, but I also don't find it very clearly, my lord. Now, my lord, issue is like this. If a reserve category candidate on his own merit, he makes it, then it is, R.K. Sabharwal said, he will not to be counted against quota, that slot will still be available. Now, if a reserve category, without being, my lord, subject to any selection, merely because by virtue of roster, he earns a promotion ahead of a general category candidate. And in the meantime, the general category candidate also catches him up before he gets further promotion. Why catch-up principle will not apply? In fact, Honorable Supreme Court, my lord, in Pavitara's case has said, in the absence of, the consequential seniority, catch-up principle is automatically revived. My learned friend says, as far as Assam is concerned, in 2002, the catch-up principle is gone. That is your perception. That's not the law of the land. Law of the land is catch-up principle will revive the moment there is no provision for consequential seniority. My lord, in Mukesh Kumar's case, Honorable Supreme Court said a reserved category candidate cannot have any grievance if state decides not to provide either reservation in promotion or consequential seniority.
Right. So what has been really decided in 6/6/2022 judgment?
My lord, in that case, what the learned single judge has decided, which according to me is wrongly, because the learned single judge has taken the view that consequential seniority is automatic. If consequential seniority is automatic, then why you need OM? Why you are saying the OM has not been expressly overruled? My lord, it's a bundle of contradictions, my lord. With all respect, I'll submit. If I'm repeating, my lord, if the consequential seniority is automatic, then you don't need OM. And at the same time, you are giving liberty to the government also that please bring out, if you want to bring out something, bring out expressly. And my lord, with all respect, my lord, my lord, in the writ appeal which we have filed, what have the learned single judge has done? A series of writ petitions were heard. However, the judgment was rendered in 2 cases. As a result, what happened, my lord?
Other cases are pending.
Are pending. That's why, my lord, we have filed yes, it is pending. All the cases are not disposed of.
I'll have to clarify.
My lord, what had happened? In the meantime, a series has also been heard by Honorable Justice Jamir, my lord. Judgment has been reserved, where we have made an argument that the learned single judge's order is per imperium, therefore it should be referred to the division bench. The judgment has been reserved. But the cases where I appear, my lord, none of them are before the, reserved by Honorable Justice Jamir. Now here the position is, my lord. Now when the state has taken a call that we will not have a policy of consequential seniority, you as a citizen, you as a person belonging to reserve category, you cannot have any grievance. Now, what is your grievance today? Your grievance is this OM is bad. OM is not bad. OM has been issued consistently with the observation of the learned single judge. I think my learned friend must have read out that page 105.
Yes, yes.
Para Roman 9.
Yes, Mr. Majmundar.
He has read out. It says, my lord, at liberty to provide reservation of promotion without consequential seniority, or at liberty not to provide any reservation in provision.
No, but consequential seniority they will have if they come in through the reserve category.
No, it's not automatic. It's not automatic, my lord. My lord, in fact, if it is automatic, then my lord, why do you need OM?
So therefore, where is the shoe pinching for him?
Him.
Yes.
Now, Sue is pinching for him because he has not, because in the absence of consequential seniority, now all the reserve category, general category candidates have stolen a march over
So
them.
therefore, according to the petitioner, if consequential seniority is given,
yes,
then he will be above these persons,
yes,
above the general category persons.
yes.
But he has not implicated them as parties.
Exactly.
It's a seniority dispute.
Yes. And more so, my lord, anyway, well, I'm not putting blame on him because I never filed any caveat. But let a copy be furnished to me also. We'll file our evidence.
The selection.
No,
that
I'm not putting blame on him.
We precipitate action. We think that this OM is precipitating and prejudicing my client.
Mr. Majumdar,
Mukesh Kumar, can I just please for a moment?
right, we'll come back to you.
Yes.
Just with the query.
Oh, page heri diyo, 12.
Your clients are from the Water Resources Department.
Yes, ma'am.
They are in the
Serial number 4 in that revised list. Rajiv Kumar Goswami.
But the revised list also is not there in total. It is half of it has been given. The court even doesn't know who are the people.
Yes, yes.
The entire list has also not been given.
Asa kyo nahi?
Page 111.
Yes.
It starts from serial number 11. Who are the people above him?
170. 107, Your Lordship.
107.
Yes, yes.
70. 170. Huh?
Yes.
170.
This
Nice.
is at
Only 119 page.
116 is the forwarding letter.
Hmm.
And 116 is the list.
117, you know.
No, this list is different from the list in page 111.
No, what is it?
What is the
That was
difference?
the earlier list.
That was the earlier list.
List that they changed, I wanted that it should be in terms of the rules. The rule says that in the cadre. I come earlier than them. So I come in the cadre in 18, my learned friend's client come to in the cadre in 20. Because the rules are very specific, rule 22 and 24, seniority from the cadre. Now what has happened? Because of this OM, they have brought me down to 17. I should have been in 2, because number 1 is the person where contempt proceeding has been drawn up by the division bench yesterday. His selection was stalled. And yes, no, I'm placing it only. So what I personally feel that the selection, my case is that definitely the
No,
selection.
he has not finished. Let him finish. Then
Yes,
you sum up your argument and we'll just.
Yes.
Mr. Majumdar was cut short a little unceremoniously.
Yes.
So if he wants to clarify anything.
Yes, yes. My lord will kindly have that delay.
Okay.
Please come to para 18, my lord.
Yes.
The direction that was issued to the state government to collect quantifiable data pertaining to adequacy or inadequacy of representation of person belonging to scheduled caste and scheduled tribe in government service is a subject matter of challenge in some of the appeals before us. In view of the law laid down by this court, there is no doubt that state government is not bound to make reservation. There is no fundamental right which inheres in an individual to claim reservation in promotion. No mandamus can be issued by the court directing state government to provide reservation. It is abundantly clear from the judgment of this court in Indrasani, Ajit Singh, Nagra, Journal, and that Article 16, 4A, 4 and 4A are enabling provisions, and collection of quantifiable data showing inadequacy of representation of scheduled caste and scheduled tribe in public service is a sine qua non for providing reservation in promotion. The data to be collected by the state government is only to justify reservation to be made in the matter of appointment or promotion to public post according to Article 16, 4 and 4A of the Constitution. As such, collection of data regarding inadequate representation of members of scheduled caste and scheduled tribes, as noted above, is a prerequisite for providing reservation, and it is not required when the state government decided not to provide reservation. Not being bound to provide reservation in promotion, state is not required to justify its decision on the basis of quantifiable data, showing that there is adequate representation of members of scheduled castes and scheduled tribes in service. Even if under representation of scheduled castes and scheduled tribes in public service is brought to the notice of the court, no mandamus can be issued by this court to the state to provide reservation in the light of law laid down by this court in Seniority. Now tomorrow, my lord, what is the prayer of my learned friend? That, my lord, consequential seniority should be revived. Your lordship cannot issue a mandamus. My lord, the Act of 2012, it does provide for reservation in promotion. So therefore, we are not saying that there cannot be any reservation in promotion.
No, that's right, but his primary case as projected
Yes.
yesterday during mentioning and today in the first half,
Yes.
that this OM is in violation of the single judge's order.
No, OM is in the 101% consistent with the single judge's order, because single judge, my lord, one thing has not been brought up to your lordship's notice. Now, my lord, our argument was by necessary implication, OM of 12/3/2002, which confers consequential seniority, stands superseded. Because there are two subsequent notifications, 29/12/14 and 3/8/16. Now, what does 3/8/16 says? If a reserve, supposing after completing the roster, my lord, there are still reserve category candidates available within the zone of consideration. Now, in that case, he is entitled to be considered for further promotion. There the OM says his case will not be considered if his earlier seniority was on account of accelerated promotion. Meaning thereby what? Meaning there is no consequential seniority. In fact, my lord, we placed Honorable Supreme Court judgment also, where Honorable Supreme Court says that there will not be any presumption in favor of repeal. But if the two cannot be reconciled, then my lord, the natural consequence is by the letter, the earlier notification is repealed. Here, my lord, 12/3/2002 says consequential seniority. 29/12/14 and 3/8/16 says no consequential seniority. That there the learned single judge at para 9 at page 105 say, now you bring it, do it expressly. That sentence is there, my lord. They expressly have put it at present.
All right, then we have to now wind up. It's.
Yes, I'm sorry, my lord.
Other cases will also have to wait.
Correct.
Mr. Das, in the meantime, please take instruction from your instructing counsel, whether you would be open to do something to implement the other.
Yes, immediately I'll implement.
But without that, we'll not pass an interim.
Yes, my lord, 104, my lord, page 104.
Huh?
If ordered, will.
How will you do it? By filing application, or you want to withdraw and file afresh?
No, not withdraw.
Because without the pleadings also, if you implead, what?
Because I have already categorically stated why I could not make them a party, because I am expecting a precipitation of an issue.
Then you file an IA, tomorrow you bring.
Yes, tomorrow I'll bring an in, but I have a submission to make before Lordship closes the act.
My lord, 104, my lord.
No, Mr. Das, you see, I've got a feel of the matter. It's not that issues are not debatable. But there are some technical issues
But
which
one
cannot.
issue I
be-
like to place, if your Lordship gives me one.
You want a complete blanket stay of the.
No, I don't want, I know my.
That order I will not pass. If
I'm
you
not
want,
putting
you
a
can-
blanket stay. What I want to convince that the Assam government rightly now had made it clear, my learned friend on both sides have clearly come to a point that they will not give the benefit of consequential seniority because the learned civil judge said you either give or not. Then your Lordship will come to page. This is my.
So that matter will have to be thrust out in the
No,
division
but,
bench.
Can I not place my case on that point? Because they have, the Lordship has said that I'll give you a chance to counter. So, yes, well, it's a very important, but this is the beauty of the judicial process. We debate.
My lord will kindly come to 104, my lord. My learned friend gets
Is
excited.
there any scope of coffee break in this kind of
Of course.
situation?
Of course.
Yes.
I don't know whether Mr. Das is still.
He's too obsessed to have coffee now, my lord.
Huh?
He's too obsessed to have coffee now.
Well, the American Supreme Court, they have coffee breaks.
America. Yeah, we should look towards America also.
Yes,
My
but
lord,
we follow the
my
process.
lord, evening courts and my lord, why confine ourselves to coffee? Maybe something more. We do not know. My
But that suggestion is not coming from the potentially intellectually loaded persons. That's the problem. Anyway, you'll get that chance.
Just 1 minute, my lord. Page 104.
Yes.
Why I am saying the government's action is perfectly consistent with the judgment. Please come to Roman 3.
Yes.
That being the position, this court unhesitatingly holds that the policy of providing reservation in promotion with consequential seniority being holding the field as per OM dated so and so, state is not within its competence and jurisdiction to deprive such service benefit to meritorious reserve category. My lord, this word meritorious is, my lord, misnomer. There's no question of meritorious reserve category candidate because his merit was never judged. Yes, reserve category, and that too without expressly bringing such policy by superseding the benefit granted under OM so and so. Now Roman 3:2, my lord. Office memorandum shall hold the field till such policies expressly repealed by the state. Now the state has expressly repealed it. Roman 2. OM dated 12/3/2002 shall hold the field till such policies expressly. And on the contrary, in the same judgment, the learned single judges said that this is automatic. 1 second, my lord. Huh? Yes. Yes. No. Liberty paragraph. No. 1 second, my lord. Automatic delivery process. Yes, please come to page 101, my lord.
Yes.
Roman 2. It is well settled that consequential seniority is a consequence of reservation in promotion and not an additional benefit. If it is not a benefit, then why do you need OM of 12/3/2002? You don't require that OM of 12/3/2002. So therefore, my lord, the judgment, normal the position is like this. I'll just conclude it in 1 minute, my lord. Supposing, my lord, now this 18/1/23 notification will operate prospectively. Let us be very clear about it. Now, if we succeed in the writ appeal before the division bench, then in that case, my lord, before 18/1/2003, if the reserve category candidate got, my lord, consequential seniority, that will be reversed. The position is that.
So you are one of the appellants in the division.
Yeah,
bench.
100%. Yes, that is the case.
All right. So as we come back,
Yes,
5 minutes to Mr. Majumdar and another, how much, 10 minutes?
I have concluded, my lord.
But
much.
what is interesting is
Yes,
the party which apparently is unhappy with the order and gone in appeal is happy with the government order passed in consequence to the single judges.
yes, yes. No, there partly our grievance has been made, partly in the context, my lord. Prospectively, now in group A post, they will not give consequential seniority. And my lord, partly our position will be vindicated when you win the writ appeal. And we are bound to win, my lord, the writ appeal.
It is because from judgment itself is party in favor of one party which.
And in fact,
We are bound to succeed.
and rightly so, the Assam government has applied the OM partly. That I'll, on the submission which I'll make, I'll specify.
Perhaps all of you should go to the division bench.
But the state never went on
The
appeal.
ambience will be better in the division bench.
State never.
Come back
went
in
on-
5 minutes.
My lord, and the
Everybody has gone together. It cannot be where we think it
I
is.
just went outside to call them.
Acha, acha. We'll take it up at 2. Yes. Next matter. Yes.
Met his lordship. In this case, lordship, petitioner appeared in response to an advertisement appeared and lordship written statement, written examination was taken, and thereafter one merit list was prepared, lordship. He stood first, lordship, in the merit list. And thereafter his case was not, he was not appointed, so this writ petition was filed, lordship, that is 12/78/2021, lordship. And during the pendency of this writ petition, lordship, respondent number 5 appeared. He filed his affidavit in opposition. He impleaded in this, in my writ petition, lordship. He filed an affidavit in opposition saying that another select list was prepared, and in that select list, respondent number 5 stood 1, lordship. And I am, my name was there at serial number 17, lordship. New marks were given, lordship. In that select list, it is reflected that the petitioner Khan obtained 37 marks. Lordship.
Department has filed affidavit.
Yes,
Lordship,
Lordship.
we have filed the affidavit, Lordship. The earlier select list has been, there are two select lists, Lordship.
Hmm.
If Lordship takes us, takes
Only
up
two.
my affidavit, Lordship.
Only two select list. What
The
happened? Why
earlier
two?
select list was not given effect because two persons have been securing the same marks were selected, Lordship.
Hmm.
That's why the director has asked for why the second, if Lordship comes to my affidavit, Lordship,
Paragraph?
page 28, Lordship, annexure 7. There's a letter from the director to the district agricultural officer, Lordship. That makes it clear, Lordship. That is the last communication to the district
Yes.
agricultural officer, Lordship.
Yes.
With reference to the subject cited above, I am to inform you that in response to a letter, your reply was received by your letter number and name of Shri Raj Khan, who is the petitioner in the first writ petition, Lordship, who has secured highest mark of 48, was recommended for approval toward appointment against unreserved category post. And Shri Parkov Rava against STP category, and by the time validity of the SIU approval was expired. Lordship, now the validity is already expired, Lordship. Way back in 2021, Lordship.
But Lordship, it was extended up to 31/3/2021, and within the extended period, we have filed our writ petition.
But is there any order extending the validity?
Yes,
No,
Lordship,
Lordship, during second valid expiry was Lordship, validity was extended till 31/3/2021, Lordship.
Correct, but is there any judicial order extending the validity of this?
No, Lordship.
no judicial order.
Then you have to check out, there is a recent judgment we have delivered in a PIL,
Lordship.
Nagaland matter. Hmm.
Lordship.
At least you can't get any relief in this court. Have you read the judgment?
No, Lordship. But Lordship, in the meantime,
Huh? Hmm.
but Lordship, the first select list, without cancelling the first select list, whether the second select list can be, Lordship.
Second select list is under challenge.
I have not challenged Lordship, but Lordship, in my,
And your client was the first candidate.
yes, Lordship, first.
Then the second select list, his name is not there.
Yes, his name is there at serial number 17, Lordship.
First one, he was first and
First,
next he was
Lordship.
17.
Yes, Lordship.
But why have you not challenged the second select list?
Lordship, thereafter the government filed their affidavit in opposition, Lordship, briefing the entire facts of the case, your Lordship. As Lordship, review was done only because.
So anybody has been appointed from the second
No,
select list?
Lordship.
Lordship, the director's view is that the director has requested the district agricultural officer, Lordship, that you are therefore requested to take proper decision in the district selection committee, even to the extent of conducting the re-examination amongst the selected candidates in respect of both the categories of STP and unreserved.
So therefore, the earlier select list, whether it's first select list, second select list, both are gone.
That is what, Lordship.
No, as per that letter, Lordship, re-examination
Re-examination
between
was
the,
selected.
among the selected candidates, Lordship.
That we don't know, but the earlier select list cannot be operated.
No, Lordship, that was not cancelled, Lordship, whether any.
That has expired. Validity has expired. Yeah? Cancelled. Where is it? Annexure 6 in which?
In
No,
the
no,
minute,
no.
no, Lordship, it was in the minutes only, they mentioned that it was cancelled, but director's letter said.
So Ms.
Lordship,
Chaudhary, we can hear this matter for 2 hours,
Lordship,
but I'll dismiss the petition. There's no point in pursuing this, flocking these dead horses.
Lordship, but.
The law is well settled. There are division bench judgment.
Lordship,
If the approval is not extended and there is no judicial order saving it, it expires. This court will obviously be bound by it because I am the author of the judgment.
Lordship,
Correct.
Lordship,
Second is the list has already expired
Lordship.
and he says it has been cancelled. So you argue the matter, we will hear it.
No, Lordship, the review was directed by
All
the
right.
director.
So let's take note. And
Lordship.
this is the only matter I'll hear
No, I
today.
have not gone through the writ appeal, Lordship, writ appeal judgment, Lordship. I am not aware about that judgment, Lordship.
No, what do you want to do? You make up your mind. If you want to argue this on merit, despite knowing this, you argue, we'll take up. Then in that case, other cases we cannot take up.
No,
But
Lordship.
obviously, I'll dismiss both these petitions. You will be just consuming the court's time, that's all.
But
Your
then-
colleagues will be waiting for
Lordship.
urgent matters. They
No,
will
Lordship,
not-
in that case, Lordship will go through the judgment and thereafter your Lordship may.
You ask for
cannot-
time then,
Lordship,
then say that.
Lordship, on
So
some
that-
other day will, after going
Yeah,
through the
then you say
judgment, Lordship.
Once the select list expires and there is no judicial order, it cannot be automatically treated to have been extended. That's the law laid down. That's the division bench judgment. Even this is a judgment, then there is a recent judgment in a PIL filed by the Nagaland Bar Association there also. On merits, they succeeded, but the select list had expired very. So what can be done?
Lordship.
And then he says it has been cancelled. So it has become infructuous if it has been cancelled.
But Lordship, here I have seen that Lordship Lordship directed to review the matter as Lordship the writ petitioner and some other Banojit Kalita secured same marks, Lordship. So direction was passed to review the matter, but Lordship, after reviewing the matter, the writ petitioner was placed at serial number 17 and one new person, he came to serial number 1.
All right, you want to argue it on merit?
No, Lordship, after on. any other
Ms. R.
ground,
Chaudhary, learned counsel for the petitioner, prays for and is granted 3 weeks time to examine the latest decisions of this court on the point of validity of the select list, which has not been expired, which has not been extended by a judicial order passed during the pendency of the proceeding. Ms.
R. Bora, Lordship.
R. Bora, learned standing
For the
counsel.
Agriculture Department.
Agriculture Department and Mr. A.R. Siddharth, learned counsel for the private respondents are present. Mr. P. Nayak, you are there? For whom? Mr. P. Nayak, learned standing counsel. Finance Department is present on behalf of respondent number 2. Let these matters be listed again after 3 weeks.
Sure.
So please come prepared with the matters and let us
Sure.
finish off. If there is nothing in it, close it.
Lordship.
Huh?
Lordship, that in that case petitioner before your lordship
Hmm.
is a constable cook in Central Reserve Police Force. And page 34 is my case, lordship. After serving the force for 15 years, lordship, he submitted a letter for discharge from his service. The authority accepts his letter without giving any consultation or any future prospect. Thereafter, he preferred an application with an intention to withdraw his resignation letter. Authority allow him to withdraw his letter, but lordship, since he report for the joining, he was not allowed to join in his post, and thereafter he was discharged from the service. Page 34 is my case, lordship. Page 34, and
So it is ready for final hearing.
lordship, the pleading has already been completed in this case.
When you want to conduct the hearing? Today itself?
Lordship, that
Huh?
this lordship may take up this matter today, lordship.
How long will you take?
It will lordship that half an hour. Lordship.
Argue?
Yes, lordship, that lordship kindly comes at page 34 of my petitions.
Page 34.
Page 34. This is a letter, lordship, issued by the Deputy Inspector General of Police, RTC, CRPF.
This is in Hindi.
Lordship, that page 35 is in Hindi, page 34 is in Testing version.
No, that's not correct. In your writ petition,
Annexure 6, lordship.
no. There is no annexure 6 and then page 34 is definitely not in English.
Which is next search, Lordship got it. That order was issued on 17/9/2008.
Yes.
Yes, Lordship may read this letter. That letter was addressed to the petitioner. You had submitted your voluntary resignation letter at 22/12.
No, you first start from who is the petitioner,
Yes,
when
sir.
was he appointed, suddenly voluntary resignation.
Yes, Lordship on 2002, petitioner was appointed in the Central Reserve Police Force
Where is his appointment order?
as a constable cook, Lordship.
Hmm.
Lordship, I have not annexed this appointment letter, but it is clearly mentioned in my paragraph number 2 of my petitions.
Paragraph number,
Paragraph number 4, page 7 of my petitions.
yes,
That he was, after following the due recruitment procedures, he was appointed as a constable cook in Central Reserve Police Force.
yes. Yes, yes.
He was appointed in 2002, my lord. The appointment letter has not been annexed. My lord. Page 24, my lord.
Yes,
Lord, I had submitted a application for discharge from service. My lord, I did not have a copy of it. Lordships kindly have the affidavit in opposition, my lord. They have annexed a copy of it.
page number,
My lord, the page number 27 of the affidavit in opposition. 80,
Running page 8.
running page 80.
running page 80.
80.
Subsequent copy. Original is 81.
Yes, that's in Hindi.
It's in Hindi, my lord. The type copy is given at page 79. My lord, I was trying to refer to the Hindi part because my lord, here lordship could find the word is discharge. My lord, he had sought for voluntary discharge from service after 15 years in service, my lord. And here, my lord, prior to this discharge, my lord, on an earlier occasion, he had submitted his resignation, withdrawn the same, was allowed to join back. Now, after this discharge application, my lord, they now bring on an on record and undertaking at page 81 to show that I had given an undertaking that I will not withdraw from the discharge. At page 83, lordship would find the so-called consultation given to me, my lord, the original of which is at page 84.
Page
83, my lord, is the translated version. Page 84 is what they say was a consultation given to me, explaining the difficulties that I may face on taking the discharge. And lordship may kindly note that it is actually from a CRPF mess stock register. It is not from any official document. At
all right.
At page 86, my lord, my discharge was, my page 87, the discharge was, my lord, accepted. Here, my lord, what they did at paragraph 4, while accepting of discharge, at page 87, my lord.
Hmm.
While accepting my discharge at paragraph 4, my lord, they said, therefore, under provisions contained in Rule 17 of the CRPF Rules 1955, resignation oblique discharge tendered by so and so is hereby accepted. So here, my lord, they introduced the term resignation. Well, this was on 22nd of December 2017. My lord, on 10/1/2018, I made an application to be reinstated in service, my lord. And at page 89, my lord, they allowed my prayer and asked me to come back and get reinstated. Page 89, my lord. Due to your domestic problems, you have submitted application for accepting discharge from service. You have been properly briefed about the unforeseen financial problems thereon due to discharge. Even though you were rigid for accepting discharge, accordingly, your resignation discharge from service is accepted. Wider application, you have requested for reinstatement into service on same post on this institution. Therefore, if you are interested to rejoin or include in the force, then you may report to this institution within 10 days, along with sworn affidavit, in which it is described that I am not rejoining the service of pressure of my family members or others, whereas I am rejoining the force on my own willingness. Consequent to this, my lord, I reported back on 2/5/2018. But here there is a,
Thereafter, what happened? Page?
my lord, when I, at page 91, my lord, when I reported back, they asked me to fill a few documents. I filled them, I signed them. And they asked me to come back and say that you come back and we'll take your acceptance again. But now, my lord, they come up with page 92, translated version is page 91, where they say, with due respect, it is submitted that I, force number so and so, reported in CRPF Cape on 2/5/2018 for completion of GPF risk fund final payment forms. After completion of GPF risk fund final payment forms, I am proceeding back to my home. In view of the above, it is requested, intimated that I am proceeding back to my home after completion of the required task for this act of kindness. I shall remain grateful to you. My lord, this is what they have come up. When I filed my first petition, they brought in this document. Now, lordship, I had made again an application in the month of July, asking them to reinstate me, to which they replied, my lord, at page 93. Which is a translated version, my lord. Page 94 is the original. May I read, my lord, page 93. Para 3 is important. While your application dated 10/1/2018 submitted to this office, in which you were requested for reinstatement taken back into service on the same post of this institution, after completion of all due formalities in accordance with the instructions on the subject, your request was accepted by the competent authority. And while letter number dated 13/4/2018 was issued to your home address with direction by giving 10 days time period to report. But on receipt of letter issued by this office, you reported in this institution on 2/5/2018. And instead of joining the service, you have completed your final payment forms, whereas you have provided opportunity to rejoin this service, but you have not availed the opportunity provided by the department. Therefore, you have neither rejoined the service within prescribed time period nor made any correspondence. Hence, your request as made by the application dated 26/7/2018 for reinstatement in service is rejected. Thereafter, my lord, I had filed a writ petition. Liberty was granted to me to file a representation before the highest authority. I have filed a representation and the representation has been rejected, my lord, at page 95. Page 95 onwards, my lord, after describing the history of the story of the at page 97, lordship would find the findings of the authority, my lord. Whereas I have carefully gone through all concerned records of the case vis-a-vis averments of the petitioner in the backdrop of the judgment dated 10/2/2021 pronounced by the Honorable High Court of Guwahati in WPC number so and so filed by the petitioner, and my observations are as under. The petitioner was enlisted in CRPF on 9/11/2002. He had submitted application for discharge from service on 22/11/2017, along with an undertaking that he had taken decision in his senses and he was not suffering from any physical or mental illness. He was produced before the competent authority for interview and he was explaining in detail about the financial hardship that he may face if he leaves the job. He was also explained the benefits of pension if he continued in service for 5 more years, but he did not pay heed to the counseling and pressed for discharge immediately. After recording the same in the interview register, his discharge application was accepted under Rule 17 of the CRPF rules with effect from 22/12/2017 by the competent authority, that is the commandant, by order number so-and-so, which was served to him. After proceeding on discharge, he submitted an application dated 10/1/2018 from his hometown for withdrawal of his discharge application and to permit him to rejoin duties, which was considered by the RTC Rajgir. And he was directed to rejoin duties within 10 days by the RTC Rajgir, letter number so-and-so dated 13/4/18. He did not report for duties within the given time. However, he reported to RTC Rajgir on 2/5/18 after almost 19 days from the date of issuance of letter. He submitted an application stating that he had reported to fill the papers pertaining to his terminal dues like risk fund, GPF, etc., and that he would return home after completion of the same. Accordingly, after submitting the necessary forms, he left the camp on the same day on his own. Thereafter, he had made another representation dated 26/7/18 from his home requesting permission to join. DIG RTC CRPF, while letter number so-and-so intimated that his request for rejoining duties could not be accepted, as on going through his past record, it was observed that while he was posted in 136 Battalion, he had submitted application for discharge, which was accepted. But on his request, the same was withdrawn. Similarly, his application dated 22/12/17 for discharge was accepted by the commandant RTC Rajgarh. And his request for withdrawal was also accepted, which was conveyed to him by letter dated 13/4/18, but he, instead of joining duties, had reported at RTC on 2/5/18, filled up the forms for payment of terminal dues and left on his own after submitting an application that he had come only for the completion of final papers. Therefore, his request was unliable to be considered and hence rejected. Having put in more than 15 years of service, he is expected to be aware of the service rules. However, as observed, despite his inconsistent behavior, having put up request for discharge twice, his request for withdrawal of his application was accepted within the provision of extant rules and considering his request empathetically. Therefore, the plea that he was not aware of what document or paper he was made to sign is not acceptable in his government sign afterthought. Furthermore, the other grounds put forth by him such as his health condition on the day, that is 2/5/18, educational background, under metric, and ignorance of knowledge are found to be not tenable. Therefore, in the light of the above, considering all aspects of the relevant to the case, undersigned hereby rejects the representation.
What is wrong with it?
My lord, settled position in law, my lord, is when a person asks for discharge from the Central Reserve Police Force, my lord, there are certain norms to be followed. One of those norms include that he cannot be discharged prior to 2 months from the day on which he asks for the discharge. Everything has to be explained to him. All the consequences of his submitting his resignation has to be explained to him. In this particular case, my lord, 2 things have happened. One, he prays for a discharge, which is converted into a resignation. Had he been given a discharge, not terming it to be a resignation, he would be entitled to some part of pension, as well as the pension is available on completion of 10 years of service. So terming it to be a resignation, my lord, is the first wrongful deed on the part of the, my lord, respondents. Secondly, my lord, not giving him the ample opportunity or time or discharging their duty in trying to explain to him prior to accepting his discharge or resignation, however they take it, my lord. That has been set aside by this honorable court on earlier occasions. If I may, my lord, refer to the judgment, my lord.
So in this writ petition, are you selling this order seeking reinstatement?
My lord, I had a discussion with the petitioner, my lord. Now, my lord, in case the order is set aside, my lord, his acceptance of resignation or discharge is set aside, my lord, he is ready to join back his service, or in the alternative, my lord, if it is taken to be a discharge proper, if it is kept as a retirement, giving him the pensionary benefits as would be applicable to him in 15 years of service, my lord. Even then, my lord, he is satisfied.
What is he entitled to? 15 years of service? What
my lord, 10 years of service, it becomes pensionable service, qualifying service. 20 years, he gets the full service. At 15, he gets whatever is applicable at 15 years.
Where is the rule?
My lord, CCS pension will do. Pensionable service 43 by 47, no? 47 or so. Rule 47, my lord.
So are you saying this resignation or discharge, whatever you call it, it was forced upon the petitioner, it was not
My lord,
voluntary?
it was not exactly forced upon. That is not the case of the petitioner, my lord. When he had submitted the discharge, when he had asked for the discharge,
Hmm.
prior to that, my lord, he had overstayed his leave, he had gone back. For the petitioner, something took place there. For the respondents, nothing happened, he gave it on his own. But even after he had submitted his discharge certificate, the request for discharge, he was allowed to go home on the same day, my lord. The same day that discharge request was accepted by the commandant.
But according to you, 2 months,
My lord, that is what the judgment says, and that is what the CRPF rules also say, that he cannot be discharged prior to 2 months. If it is a resignation, it has to be 2 months, number one. Number two, the commandant has to take a conscious decision. What would be the effect on him? Thirdly, my lord, there has to be another decision. What would be the effect of such a resignation on the force itself? These three things had to be considered by the commandant before he accepted the discharge. Could not have been considered within the same day. My humble submission.
what is he doing now?
My lord, he was initially a cook. Now he sells locks, my lord, those locks from shop to shop.
What
Locks, my lord, those
Achha.
delivers locks from the company to different shops. My lord. And there is one judgment of the Gujarat High Court, my lord, if I refer to that, where, my lord, the Honorable Court has said that if a person gives an application for voluntary resignation, since there is no concept of a voluntary resignation, it has to be accepted as a voluntary retirement, application for voluntary retirement, and whatever pensionable dues are due to him should be paid to him. My lord. So at this stage, my lord, perhaps he's a man who
Have
has.
you read the judgment he's referring to?
No, Lord.
Otherwise, Lordship, he prayed for discharge on the same day, Lordship, and he was explained by the authorities about the application of his discharge on that stage, and asked him to continue for furthermore, Lordship, 5 years for retirement benefits to get Lordship. But he insisted for discharge, Lordship, and after that, it was accepted by the authorities and allowed him to go on discharge. But the point is, Lordship, after he submitted application for rejoining in service, Lordship, he was allowed to rejoin in service, but he has not come to join in service. And after within 10 days, he was allowed to join. After 19 days, he appeared before the authorities and asked for release of his due, Lordship, GPF, etc. Therefore, it is his fault, Lordship, he has not joined after allowing to rejoin in service. And now he cannot challenge this order because he was allowed to join.
No, joining may not be possible, but what do
Yes,
you
Lord.
say to his plea
Pension,
that
Lordship.
some pension can be paid to
This
him?
is,
CCS pension
there is
49.
no prayer of Lordship release of any pension or anything, Lordship. He is only praying for rejoining in service, passing of the order.
All right, even if there is no prayer, can you examine this matter and come back to us?
Lordship.
You can fix it on, you have not prayed for any.
My lord,
No, no,
the
Lordship.
prayer in the
Nothing has
repetition
been
is
prayed
for
there.
setting aside of the discharge.
Hmm.
For that, my lord, I have relied upon the judgment passed by this Honorable High Court, and my lord. Now, since, my lord, even I feel a man who submits his resignation or discharge twice, remains absent from duty 19 occasions, is reserved
Difficult.
13 occasions, need not go back. But, my lord, he need not go back dry to home. He need not go back what they call sukha to home, my lord. What he takes back a pension, my lord, it's enough for him. And I have made it clear to him that if pension is what he gets, if the discharge is taken to be a voluntary retirement application and the pension is what flows down, perhaps, my lord,
So you both of you examine this issue.
Lordship.
the Gujarat High Court judgment also have given where voluntary resignation concept cannot be there, my lord. It has to be a voluntary retirement if it is pensionable service. And, my lord, it will be rule 49 of the CCS pension rules, my lord, 10 years of service.
Rule 49.
My lord, CCS pension rules, 72.
Otherwise,
He would be
also-
entitled to gratuity also.
Lordship, otherwise also he was not a disciplined member, Lordship, because 13 times he leave the.
But that is all right.
Yes.
He is also saying, and the court is also of the view
I
that
will take
this is not a
instruction
case of
on this point.
reinstatement.
Yes, sir.
But if under the rules, if he is entitled to some benefits, that should be given to him. Because not giving that benefit to him means you are penalizing his family. And in any case, if these are available under the rules, it should be given.
If I may just read out my the Gujarat High Court
Since
judgment.
it is not his case in this respect, Lordship, regarding pensionary benefits.
All right,
I will take instruction in this matter, Lordship.
we'll record it and you
Lordship.
see, these technicalities in these matters don't matter. We can ask him to amend the petition, but how does it help you?
Lordship, I will take
You
instruction.
can
in
get
this
4 weeks maximum.
matter. Lordship.
After that, you will be in that point.
Yeah.
So tell your clients not to get into technicalities. Technicalities, we can handle it in half an hour.
Yeah.
But examine whether under the rules, even if a liberal interpretation is given to his version,
Lordship.
which we will give, if he comes within the domain of the rules, then what is the stand of your client? How much time will you require for that?
Lordship, next week it may be fixed.
Huh?
Next week it may be fixed. I will take instruction.
Next week? Next week, which day?
Hearing the.
We'll have it on 2nd February then.
Lordship.
Heard Mr. R. Majumdar, learned counsel for the petitioner, also heard Ms. R. Devi, learned counsel, assistant, your learned CGC, appearing for the respondents. First up. In this writ petition, the order dated
April 21.
16/4/2021.
16/4/2021, issued by the Director General, Central Reserve Police Force, rejecting the representation filed by the petitioner to allow him to join back on service after having been discharged on the basis of his own application. The present petition has been filed. Full stop. After hearing the submission of learned counsel for the parties, this court is of the prima facie view that having regard to the conduct of the petitioner, more particularly the fact that he had admittedly submitted applications for discharge on as many as 2 occasions. And in one occasion, when his prayer was allowed by the authorities and he was asked to join back, the petitioner has failed to do so. The facts and circumstances of the case would not justify an order of reinstatement. Full stop. However, Mr. Majumdar submits that since there is no concept of voluntary resignation in this case, hence the petitioner's application ought to be treated as an application for voluntary discharge. And in that event, considering the fact that he has spent more than 15 years in service, the petitioner would be entitled to how much
My lord, he-
partial pension.
pension.
The provision of Rule 49 of the CCS Pension Rules 1972. First up. Since there is no specific prayer made on that behalf in the writ petition, Ms. R. Devi, learned CGC, submits that she is not in a position to readily respond to such a prayer and therefore seeks 1 week's time to obtain instruction. Prayer allowed, let this matter be listed again on 2nd February 2022 as a fixed item.
I'm blessed.
You can take back this for now.
In this matter, Zehli is supposed to Aguda matter. He's on left, for number 8. After some time or some other relative.
What is this matter?
Matter relates to the sending the training course of the Lakmundal, Amin, etc. It is not qualified for in the written as well as oral examination, but they have not selected the petitioner. One interim order is
We'll do it some other day then.
31st.
Huh?
31st.
First week of February, that's it. First week of February, that's it.
Heard Mr. A.B.T. Hawk, learned counsel for the petitioner. Also heard Mr. S.
Yes,
Dutta,
doctor.
learned government advocate,
Standing council,
standing counsel,
revenue and disaster.
Revenue and Disaster Management Department, Assam, who prays for adjournment in this case with a prayer to list the matter again in the first week of February. First of Mrs. Burwal, learned government advocate Assam, is also present. First of, in view of the prayer made by the learned departmental council, let this writ petition be listed again in the first week of February, 2023.
Item 6.
Lordship, we could not file the affidavit, Lordship, further 1 week time may be allowed to file the.
You are appearing for whom?
I'm appearing on behalf of respondent number 2, Lordship.
Respondent number 2.
Respondent number.
Heard Mr. M. Haloi, learned counsel for the petitioner. Also heard Miss
And Dekaraja, Lordship.
N. Decker, learned counsel appearing on behalf of the respondent number 2, who submits that due to want of instruction, affidavit on behalf of our client would not be filed. Full stop. As such, further 2 weeks' time has been prayed for by the respondent's counsel, by the counsel for the respondent number 2, to obtain instruction and file affidavit. Full stop. Mr. J.
No one.
You have filed affidavit?
I've got instruction.
Acha, Mr. J.K. Parajuli, learned government advocate Assam, submits that government advocate Assam appearing for the respondent number 1 submits that he has received instructions and therefore be granted 2 weeks time to bring the same on record in the form of an affidavit. On the request of learned counsel appearing for the respondents, this matter stands adjourned for 3 weeks so as to enable them to file affidavit. Stop. Interim order passed earlier to continue.
Much.
For hearing item 8,
Let me perhaps refer in the last occasion, what was the director as these Salsa state authorities to find out if anything can be done for the child who had sustained disability. But accordingly, the Salsa had written to the authorities concerned over here. Now, the organization here does not deal with upper limbs. They only deal with lower limbs. And then the organization gave us the address of the Jaipur authority where we could perhaps contact them for the upper limbs. Accordingly, the Salsa has written to them. They asked for updated photographs of the child. Now, Lordship, there was some issue with the photograph because the child does not like photograph. We explained to the council, and then yesterday, certain photographs have been forwarded to us, which today, unfortunately, the Salsa office is closed, Lordship. I'm not sure for what reason. By tomorrow, I should be able to send these photographs to the Salsa office and we'll accordingly proceed. If perhaps the matter is taken up next week, I should be able to give some certain, if you also just take up the instruction for a moment. The last page.
But is there a possibility that they would be able to do something about it?
Lordship, only after looking at the photograph will they be able to assign whether actually an artificial limb can be. That is what I wanted to point out to your Lordships. The last page of this particular instructions. If you also will just read the email which has been sent to us. There.
Yes.
Last page. Dear sir, this is with reference to your mail seeking information regarding possibility of fitting artificial upper limbs to Pragyan Vaishya. Our organization does fit artificial upper limbs, but I will be able to confirm our ability to help Pragyan if we know the precise level of his amputation. Kindly arrange to send a photograph of the child's hands. Best regards. Now, what we had sent was a very blurred kind of a black and white picture, which they could not figure out whether it was actually possible or not. So they asked for colored photographs, which my learned friend has yesterday forwarded it to me. Some photographs, which I'll produce before the authorities. And like I said, if next week the matter is taken up, I should be able to have at least the instructions as to whether they'll be able to actually assist him in the matter by providing him with the hands, or whether it is actually possible to have those hands fitted over there. That is not the question.
All right.
Now-
Now, Mr. Mahanta, yes.
Well, the services of the Jaipur organization was already availed by the victim, my lord. In fact, from what I have learned, my lord, that Jaipur organization, although they are into prosthetics, but upper limbs are only cosmetic, my lord. Now, cosmetic prosthetic would not work. It has to be a mechanical prosthetic, my lord, with movement in the elbows and the fingers, my lord. That was already fitted, my lord. The prosthetic from the Jaipur organization was already fitted fitted, my lord, when there was a camp by the Asalsa, my lord. The father of the petitioner is also present, my lord. That was fitted, but it didn't work, my lord. And thereafter, my lord, the father had again approached Autobac and he bought a mechanical arm, my lord, which was worth around 7 lakh rupees. That arm, my lord, only the fingers were movable, my lord. But that didn't work for a long, after some time, my lord. So therefore, my lord, the Autobac company had instructed the father that let him grow, let him reach a matured age. For example, around 18 and 19, then we can fit him with the mechanical arm, what we have. But now it is too early because he's frail and fragile. So the prosthetics won't, my lord, he won't be able to be fitted with the prosthetics.
From
But
the
the
photographs
father,
which have been annexed, the amputation is here, somewhere here, your lordship.
even lower.
So the weight of the arm itself is quite heavy, and perhaps the muscles only of this portion will not be able to sustain the weight of the device. That is the difficulty which I think my own friend will
The
face.
father is present, my lord.
Sir, Jaipuror jitu pare company asile, ita honorable Chief Justice, my name Paurisu, Otrofano asile, our Chief Justice, Honorable Mr. Ranjan Gogoi, তেওঁলোকে মোক লগ কৰাই দিছিল। মই যেটো হাত লগাইছো ইয়াত তাৰে তেওঁলোকে মোক তাত হাত লগাব মাতিছিলে, গৈছিলো। আমি ইয়াক তাৰ আগতে অটোবকৰ হাত লগাইছো। কোম্পানীয়ে কৈছে এওঁ যেটো হাত লগাইছে আমাৰ ইন্ডিয়াৰ ইটোৱে নবনে, আমি এওঁক আৰু কি হাত লগাম। এটা চিফ জাষ্টিছে কৈছিলে এওঁক ভাল হাত লগাই দিব লাগে। কি ডিপাৰ্টমেন্ট আছিলে জিপিএছ লিগেল সাৰ্ভিস অথৰিটি, কিন্তু তেওঁলোকে নলগালে। তাৰ পিছত মই নিজৰ পইচাৰে এই হাতটো লগাইছো।
এতিয়া আপুনি কি বিচাৰিছে? কেনেকুৱা ধৰণৰ সহায় বিচাৰিছে আপুনি?
সহায় হ'ল ছাৰ তাৰ ভৱিষ্যত ইকনমিকেলি আৰু ছচিয়েলজিকেলি তাৰ সুৰক্ষিত হ'ব লাগে। এটা আৰু মেকানিকেল হাত এটা আছে, এইটো তাৰমানে ইয়াৰ সেই সময়ত অলপ মাইনৰ এজ আছিলে, এফেক্টিবল নহয়। তেওঁলোকে কৈছে ই অলপ ডাঙৰ হলে আমি এইটো ট্ৰাই কৰিম।
ক'ত আছে মেকানিকেল হাত?
অটোবক কোম্পানী।
Autobox.
Autobox is a German company, deals with prosthetics.
আপুনি এইটো ট্ৰাই কৰিব খুজিছে নেকি?
এটা লগাইছো, এইটো মানে অলপ কম দামী। এইটো হাতটো এইটোহে কৰে, লিখিব পাৰে, জাষ্ট অলপ বেন কৰি লিখিব পাৰে, কিন্তু পুৰা মুভ নহয়। এইটো অলপ লাইট। ইয়াৰ পিছত আছে এটা মেকানিকেল বুলি কয়, সেইটো 18 ইয়াৰ্ছ মান এনেকা অলপ মজবুত হ'ব লাগে। সি অলপ দুৰ্বল আছিলে, সেইকাৰণে তেতিয়া চাকচেছ হোৱা নাছিল, লগাব পৰা নাছিল। মই তো 4-5 বছৰ আগতে লগালো আজিৰ পৰা, তেতিয়া সৰু আছিলে।
তাৰ বাহিৰে আৰু কি বিচাৰিছে?
তাৰ বাহিৰে ছাৰ তাৰ ভৱিষ্যত সুৰক্ষিত হ'ব লাগে, যাতে আমি মৰাৰ পিছতো তাত দিগদাৰ।
ঠিক আছে, আপুনি বহক।
We have filed an affidavit today, my lord, regarding the appointment, my lord, consideration of appointment. My lord, on achieving the age of 18 years, we have filed an affidavit that extended to be considered for appointment in the grade proposed, taking into account his qualification. That affidavit is not in the record, we have filed it today, my lord.
My lord, the affidavit says, my lord.
Just a minute, just a minute. Grade 4 post in which department?
My lord, public safety engineering department or any other authority under the authority of KSC, my lord. Under the PAC department, he is working as superintendent in that particular office also, my lord, in the office of the additional chief engineer of the PAC department. In the PAC department, there are certain vacancy will come in the year 2024 and 25. Definitely at this stage, as he has not submitted his application for appointment, he has not attained the age of majority, my lord. So we have filed to the extent that we will consider favorably for his appointment when he attained the age of majority and taking into account his qualification, my lord. We have filed affidavit and we'll take into action on that.
That affidavit is not on record.
Not on record today, my lord. We have filed it today, my lord.
Would your client be satisfied if that
My lord,
happens?
that would be my ask the client, inquired with the client, my lord, the father of the client, he'll be satisfied. But the affidavit says, my lord, I'll just read out one line. It says the consideration for appointment will be made after attaining the age of 18 years, taking into account his educational qualification and suitability of the petitioner for the particular post. Now, I have doubts, my lord, because as far as the education goes, my lord, he discontinued studies after class 7. And suitability, classic, and suitability for a post, my lord, if
Well, we can clarify it, my lord, regarding that some guest house or some that
So,
public.
why can't we consider, Miss Chaudhary, you also please, you see, I'm not in a hurry to close this matter. We will have to monitor for some time. So, this employment and suitability, these are all eye washes. Why can't he be given some pension? Some financial assistance in the form of a pension or some assistance from the state, which helps him live his life in a decent manner. Will that be a better idea, Mr. Mahanta?
yes, my lord,
Because
absolutely.
without both the arms, he is unsuitable for any job.
My lord,
What suitability would you?
there may be some posts are there, my lord. I talk with them, my lord,
Hmm.
that some guest house are there or the reception center is there. He can only sit there and he can talk with the people.
Hmm.
Like that, you, my lord. That type of accommodations are there. The father of the petitioner is there. He is already in that particular office he is working. He talk with they talk with the additional civil, talk with him, my lord.
All right. Now, how will you appoint him?
But we will appoint him in the grade 4 post, my lord.
How? Without a selection process?
My lord, in the disability quota is there, my lord. 5% post is there, or 3% post disability quota is there. Against that post, my lord, we can appoint him, my lord.
So, when will he become 18 years?
My lord, we have
He's
said that
16 years odd, my lord, now.
no, he will attain the age of my lord.
He's
Majority,
16
my lord.
years, my lord, born on 2014.
He born on 15/6/2006, my lord. He will attain the age of in 2024, my lord. In June 2024, so we have specifically stated against the vacancy of 2024-25, my lord. We have made a specific statement, my lord. Regarding the appointment, my lord, as he has not attended, my lord, so we could not file that.
That's all right.
My
That's
lord,
all
that is
right.
the
We can provide it
My lord,
by a judicial order.
if you're planning, my lord, definitely that
So,
definite instruction,
first thing is, as far as the limbs are concerned,
my lord.
who is for the government here? Who is appearing for the government of Assam? Can anybody request, can you request one of the additional advocate general, or if the AG is around, to just, the advocate general is there? Just inquire if anybody is available, if you could come. So, we are looking at first his prosthetics. We will explore if the state can bear the expenses. Why should he bear the expenses? Let the state bear. It's a welfare state. And in any case, it's a case of negligence by the state. The idea is to give him comprehensive relief so that he can live a decent life. What has happened cannot be undone, but how can it be minimized? Right. So first idea is to give him a artificial limb, which at least gives him some relief. At least he is independently able to live his life. That is the first point. The second is securing his future. That we do by ensuring that he gets a job under a disability quota, and that can be provided by a judicial order passed in this case. The third is if he has medical requirements in terms of, say, counseling, psychological issues, etc. Then what is to be done? If you can throw some light and give some assistance. Let me just finish. And the fourth is, where is PhD department? Fourth is there has to be some compensation also.
Lordship's compensation, to my knowledge, was paid by the APDCL because it was the negligence of the
So now
APDCL,
it
and
is
they had paid
PhD
certain
's
amount of. I'm sorry, and maybe.
No, that was an interim financial relief. So there will be more financial liability, both of APDC and PHE. These are the four things. No, but the building was a public health engineering.
Yes, but the subject itself is, so the KAC will be the right person to have.
So their Karbi Anglong Autonomous Council PH is willing to give him some job.
So we are offering the appointment. After the deliberation, we are down, my lord. I took the initiative and I.
All right. So we will consider what further financial.
I had a discussion with Mr. Goswami, Goswami, he'll leave, madam, exit the federal list. He'll agree, madam, let's say, tomorrow, madam. Let's just go in madam, to direct.
Tomorrow.
Tomorrow, if I take.
Insofar as the, I'm just submitting, madam, insofar as the liability is concerned, my learned counsel appearing for the APDCL, think they are not liable. So insofar as the negligence, I'll just make one submission. They have to, both APDCL and PHE has to bear the expenses, my lord, for the compensation.
No, now, Mr. Mahanta, you have to tell us one thing.
My lord.
If we go to the compensation, we'll close the matter, give a judgment. Then we don't know what is happening.
Yes, my lord.
Compensation, you have got some financial relief. Only 3 months back, I think some amount has been paid.
4 lakhs.
4 lakhs. All right, we will consider it. But there are other issues which needs to be streamlined now. If we release the matter, those issues will remain open. You have to fight it out in another proceeding. You tell us what you want.
Well, like your lordship suggested, my lord, but some compensation so that can be kept in a fixed deposit account.
Oh, that's all right. 4 lakhs has been finished.
But
So 4
one
lakhs
arm
because,
would
my lord,
cost
the
more
arm
than,
itself is 7 lakhs, my lord.
more than 8 to 9 lakhs, one mechanized
That we
arm.
will ask the state to bear. You don't have to spend from your pocket.
Because, my lord, as
One
per
arm.
the judgments,
So
my lord,
both would be double the amount.
in the year
proper
2014, my lord, similar circumstances, the child had lost 1 limb. The Supreme Court in the year 2014 had granted 60 lakhs, my lord.
No,
As
Mr. Mohanto, your eyes are only on the money itself.
No, it's absolutely not, my lord. I'm only thinking about the welfare of the child, my lord. That's why I've agreed to all the.
No, the message should go that the life of a citizen and more particularly a child is very important.
Yes.
60 lakhs or 60 crores we'll see how the state does it.
And PHE is liable, my lord. On record, they say they did not
That is
shift the
for them
line.
to sort it out.
They did not shift the line.
But
They ought to have.
but the father of the child is not to spend a single farthing.
My lord.
This will be entirely the responsibility of the state. That will
I'm
provide.
very grateful to lordship that can be done. The only thing, the monetary part. I'm
Monetary
submitting-
will see.
Yes,
That
yes.
will be the last.
Yes.
We'll see
I agree.
what are the remedies already given. What is his requirement? There cannot be a profiteering motive in this because it's state fund. So that compensation which is justified in fact, which is deemed necessary, that will be considered. But before that, we have to see what limbs can be fitted, what job can be given to him,
Exactly.
what other comfort can be given to the family, to the victim. Once the picture is clear, then we'll go to the question of monetary. That will be the last.
And the monetary part, but I'm not even submitting that should be handed over to the father or something. It should be there in a fixed deposit account.
So
only
it
for
will
the
be
welfare.
there when it is, you'll
Only
get
for
the
the
interest. Make
Yes.
a note. These days, as we delay it, we'll give the interest to you. But financial cannot be, money is important, we understand. But the father is not to bear any expenditure till this matter is pending. Mr. Mr. Nath, this matter is troubling this court a little. And who you would like to request, if possible, if the matter can be taken up through the learned advocate general to the government at the level of principal secretary, health. You see, this is a story of a young boy who, when he was a child, it was some years back. He was playing on top of an office building, which was abandoned, with a high tension wire hanging over it. He got electrocuted. Both his arms were amputated from this. The boy's father is here. Now, you can imagine if a person loses both the arms at that level, there will be physical, there will be psychological, there will be various aspects. So this petition was filed for compensation primarily, but this court felt that the child is not at fault. What has happened cannot be undone, but this is a welfare state. We must try everything to see how we can secure him at least minimum comfortable life. So there was an order passed by the court to pay an interim amount of 4 lakhs, which the APDCL has already paid. That's just an interim amount. We asked with the Karbi Anglong Authority, PHE, whether he can be provided with a job. They have agreed to do that. It will be a grade 4 job. But he has to attain 18 years, which he'll do in June 2024. Correct. So they have filed an affidavit undertaking to do it. The third aspect we are exploring is, can he be fitted with an artificial limb? If not two, at least one, so that he can be self-dependent in his personal activities. It's a very ugly scenario to imagine what will happen. We are trying to see if such a limb is available at all or not. If it is available, perhaps we can explore if the state can provide him with that. Because he's a young boy, his future he has to live. And this is an admitted case of negligence. There is no determination is required. They have admitted that it should not have been exposed like this. And then, of course, we'll see once these things are done, he may require some psychological counseling also. We are told that the boy is depressed. Naturally, he will be a healthy boy. If you see the photographs,
I've seen it.
you will know what we mean. So, it is nothing adversarial. The Principal Secretary, Commissioner Health, if an inquiry can be made, if any help can be given to this boy now. Earlier, I think there were attempts, but then he was of a too tender age and he was not in a position to take the weight of an artificial limb, which is worth any purpose. Secondly, the technology has improved in last 4-5 years. But these limbs are expensive and the father obviously would find it difficult to bear. So on that count, can you just
Yes, absolutely.
find out what can be done?
I'll take up the matter.
If we can get some clarity, let the system do something for its people who are unnecessarily facing these problems. And then, of course, we'll consider it at the end, some financial liability on the APDCL, which will be over and above the 4 lakhs. 4 lakhs is a meager amount for this, but we'll see. Mr. Chaudhary, you can get ready on that. When do you want this matter to be fixed? This is a part-heard matter in this court, so it can be fixed.
Lordship may give me 10 days time. I'll just take it up because
You will also require a little time.
Lordships, but he's already availed the services of that particular organization, so I do not know how else it would be able to help him.
That's the problem. What exactly is possible?
But I will still get back on the instruction as to whether now it will be possible for them to actually provide.
But he's taking the name of some organization. What is it?
Same
Auto Backman, not the same organization.
Auto
Backman.
Autobox. Can you just take down the name?
Yes,
I'll take the name and the address as well.
The government can make an inquiry with the company what exactly it is.
Lordship, I'll take up the matter with the authorities and to what extent it is possible, I'll get the
All right.
instruction.
When did you file the affidavit, Mr. Chutia? Today. Take down heard Mr. P. Mohanto, Learned Counsel for Education. Also heard Ms. R.S. Chaudhary, Learned Standing Counsel, Assam State Legal Service Authority. Mr. J. Chutia, Learned Standing Counsel, KAC. Mr. D. Gogoi, Learned Standing Counsel, PHE Department, Assam, and Mr. D. Chaudhary, Learned Standing Counsel, APDCL Limited. Mr. Chutia submits that an affidavit filed on behalf of the KAC authorities, bracket PHED, bracket law, undertaking to provide employment to the petitioner in a suitable grade 4 post immediately upon his attaining the age of 18 years has been filed today, but the same is not on record. First of all, Mr. Mohanto submits that the attempts to find out suitable artificial limb that can be fitted to the petitioner's to the arms of the victim petitioner could not be traced out till now. But even if it is found, the expenses involved will be such that it will not be possible for the petitioner's father to bear the same. Full stop. Taking note of such argument, this court has requested Mr. D. Nath, learned additional senior government advocate, to examine the issue and obtain instruction from the Commissioner and Secretary to the Government of Assam, Health and Family Welfare Department, as to in what manner the cause of the petitioner can be held. Full stop. Ms. R.S. Chaudhary, learned Standing Council, Asalsa also submits that some inputs from the Jaipur Food bracket, an organization connected with fitting of prosthetic limbs bracket 2, is awaited in a week's time. Full stop. In view of the above and on the request of learned counsel for both the sides, let this read petition be listed again after listed again on 7th of February 2023 by reflecting the name of learned counsel for all the parties in the cause list. Deeply learned.
Your lordship. And it shall be that taken up at 2 o'clock, madam. Only 3 minutes late.
All right. Go. There is a motion. I think after that motion is going on. Hold on. So you have made your submissions.
Well, I made my
Mr. Majumdar, would you like to say something?
Finally, I'm responding to what your lordship was indicating about the interim order. Lordship will kindly visualize one thing: the reserve category people have not challenged this order before the division bench. As a result, if the writ appeal is allowed, they are not going to get any relief. So the question of modifying the order subsequently again, if the writ appeal is allowed, doesn't arise. This is what your lordship was thinking. So that question is not there. The reserve category people have not preferred any appeal.
So appeal has been preferred by general category.
Yes, my lord. So then this question doesn't arise. That being the position, my lord, even otherwise your lordship has seen, my learned senior colleague has just now pointed out. I am also just pointing out, I'll read it, my lord. The judgment clearly says that if by its express policy decision they take the policy of not providing constitutionality, they can do it, which has been done now. In 2-3 paragraphs, my lord, the Honorable Second Judge has made it very clear that yes, although I am upholding the validity of 2002 OM, but by an express policy, if the government decides that they will provide reservation and promotion without constitutionality, they can do it, which has been done. They have not challenged this order before the division bench. This being the position where the question of now, because they have realized this now, that they ought to have challenged it.
Now, how do you know they have realized?
These 3 paragraphs which are speaking against them, if they can make any submission to justify that and say that no, this is not going against us, then the matter will be different. But then these 3 judgments have opened it for us to take any policy decision. We have,
yeah, but then ultimately, what has been decided by the learned single judge? No,
my lord,
just trying to understand.
Fundamentally, 2 things have been decided. One, the reservation and promotion was also under challenge. That has been rejected, saying that no, reservation is there.
No, but how can the High Court declare that illegal? Because it's a
OM of 2016, my lord. In fact, what has happened, my lord, before the single judge, the challenge was twofold. In the OM of 2016, the state has provided that there will be reservation in promotion. Secondly, in paragraph 4, further provided that consecution seniority will not be there, and that is why the reserve category people did not challenge the OM as a whole, but only that part of the OM which says that there will be catch-up sure. So these are the two issues, were the two issues. Now, so far as the first challenge to the reservation and promotion itself was concerned, that was rejected. It was in favor of the state that no, reservation and promotion is there. So far as the consequences seniority part is concerned, their contention was that based on the OM of 2002, the consequences seniority is holding the field. The Honorable Singh judges said yes, it is holding the field, but that is up to the time when the state does not.
All right, got it. Pat.
Yes. So now the state has, in pursuance of their judgment, taken a policy. Now, if you want to challenge that policy, and you cannot challenge the policy, man. It's a matter of policy. Supreme Court has made it very clear. Mukesh Kumar is also there. Earlier, Paneer Singh is very clear. I can just show one line from earlier Mukesh Kumar also. Kindly have a look. Just. Let me just see when it just. And I'm just reading para 71, Sudha Kumar. So all these judgments have referred. All these. This one is Sudhakar Baburao Nangude 2020, volume 11 SSC, page 399. This judgment, my lord, has taken into consideration and practically discussed all the cases from Indra Sawhney to Paneer Singh, Nagaraja, UP State Power, all, and both the aspects, particularly the consequences scenario. My lord, may I just see one thing.
Yes.
Para 46. The issue before a two-judge bench of this court was thus: in the absence of policy decision taken by the state, rules framed, rules framed pursuant to enabling provision of Article 16(4)(a) of the Constitution of India, whether a reserve category candidate promoted on the basis of reservation earlier than his senior general category candidate in the feeder category can claim consequent seniority in the promotional post. This was the issue. Decision is like this, my lord: in the absence of any specific provision or policy decision taken by the state government for consequent seniority for reserve category accelerated promotees, there is no question of automatic application of Article 16(4)(a) of the Constitution. Very specific, my lord. And all the judgments, Paneer Singh and BK Pavitra, these are specifically dealing with the issue of consequent seniority. That being the position, my lord, I humble submission, there is no question of being state. And these has got many huge ramifications. The entire state, all these things, suddenly by way of a big petition they cannot. And they have, my basic submission, my lord, they have not challenged the judgment passed by Honorable Justice A.D. Chaudhary. And Honorable Justice A.D. Chaudhary has said in very clear terms that yes, 2002 OM is holding the field. In fact, my lord,
that you have already submitted.
Well, I'm just indicating, we as a state argued that no, 2002 is not holding the field because by implication, because 2016 OM is a subsequent one. There we have said catch-up theory, and that is why they challenged it. That itself shows that the consequent seniority has gone. And on top of that, my lord, we were asked to file an affidavit because in the language there was some ambiguity, my lord, I should admit. We filed an affidavit specifically saying that we are following catch-up theory. In spite of that, this was the finding. Yes, there was an order.
All right. This is a court order. It's a court order unless it is set aside by.
My lord, that is my submission. That is my humble submission, your lordship. That's all.
But in this case, we are only concerned as to whether the impugned OM is illegal on the grounds urged, not on the question of legality or validity.
Your lordship will examine, your lordship, but today there is no question of state.
Yes, yes, Mr. Das.
May please worship. First, I'll answer what my learned friend, Additional Advocate General Majumdar said. On the first point, I'll come up with the OM to answer the first point. He just now said that I have never challenged the judgment of the single judge. So why will I challenge the judgment of the judge? Because I have won my case. And another protection, the OM, your lordship, will come down to page 107. The 18 January 2000 23 judgment, OM has the answer for what my learned friend has said. Article 16.4 and 16, if I may read, being enabling provision, the state is at liberty to implement its policy of giving reservation in promotion with consequential, Lordship, 107.
Yes,
Without consequence, the state is at liberty to implement its policy of giving reservation in promotion with consequential seniority, comma, without consequential seniority, or at liberty not to provide reservation in promotion. However, while implementing such policy, due process of law need to be followed, including the dicta of Nagraj clarified in journal. Well, my answer is, why will I challenge it? Because I have already got the protection in the last line. While implementing the policy, they will have to follow the dicta of Nagraj. The Nagraj case is that the 77 and the 85th amendment has been upheld by the Supreme Court, stating that if you give accelerated promotion to the reserve, you will have to give consequential seniority, because if you don't give, then ultimately the entire reservation edifice will break down. As in fact, this was an argument at the journals. This was an argument advanced by the senior counsel in the Supreme Court. For the general, it was rejected by 5 judges of the Supreme Court, because the Supreme Court says if we accept this argument, then we will have to strike down 16(4)(a) and (b), which we will not do it because it has been upheld by Nagraj. But if I may help you, Lordship will come to page paragraph 34 of our judgment. I've given the, because these are matters where the state government is my submission is that they are tinkering with constitutional provision. I need to place entire facts.
paragraph 30.
Paragraph 34. Malad, what a journal, I'll just specify. Nagraj said that you upheld 16(4) and (b) with certain condition. Journal went into the issue whether
You are referring to Nagraj or journal?
no, I'm referring to journal because journal is a reiteration of Nagraj.
2018-10.
2018-10. I have given this idea.
Para 34, is it?
Yes, if I may read.
Yes, please.
We have already seen that even without the help, can I read this?
Yes, yes.
We have already seen that even without the help of the first part of the article 16(4)(a) and 12 amendment bill, the providing of quantifiable data, well, this is not required, your lordship will come to below F. This being the case, it is easy to see the pattern of article 46. Lordship, this being the case, it's easy to see the pattern of article 46 being followed in article 16(4)(a) and 16(4)(a). 16(4) and 16(4)(a). Whereas backward classes in article 16(4) is equivalent to the weaker sections of the people in article 46, and is the overall genus. The species of scheduled caste and scheduled tribes is separately mentioned in the latter part of 46 and article 16(4)(a). This is for the reason, as has been pointed out, this is for the reason, as has been pointed out by us earlier, that the scheduled castes and the scheduled tribes are the most backward or the weakest of the weaker sections of the society, and we are therefore presumed to be backward. Sri Dwivedi's argument that a member of the scheduled caste or scheduled tribe reaches the higher post, he or she is no longer has the state of untouchability or backwardness. As the case may be, therefore, the state can judge the absence of backwardness as the post goes higher is an argument that goes against the validity of 16(4)(a). If we were to accept this argument logically, we would have to strike down 16(4)(a) as the necessity of continuing reservation for a scheduled caste and scheduled tribe members are in the higher post, would then disappear. Since the object of 16(4) and 4)(b) is to do away with the 9 benches of Indraswani when it came to the reservation in promotion in favor of the scheduled caste and scheduled tribe, that object must be given effect to and has been given effect to by the judgment of Nagraj. This being the case, we cannot countenance an argument that would indirectly revisit the basis of or foundation of the constitutional amendment themselves in order that one small part of Nagraj will be upheld. Namely, there will be quantifiable data for judging backwardness of the scheduled caste and tribe, We may hasten to add that Dwivedi's argument cannot be confused with the concept of creamy layer, which as has been pointed out by us herein above applies to person within the SCST who no longer requires reservation or post to the post beyond the entry stage, which may be occupied by members of the scheduled caste or scheduled tribe. My lord, your lordship will come to the judgment at paragraph page 104. My lord, this is a counter to Mr. Majumdar's argument.
Yes.
He has said that the single judge has given us a handle. If we will give you, we will not give you. It says what? This is the determinations. The office memorandum dated 12/3/2002 shall hold the field till such policy is expressly repealed by the state.
This is what we have done.
Mala, this is the stand of the state government now that we have expressly repealed that provision of not giving you consent. We will give you one part. If so, why did the additional advocate general in a similar case before the Guwahati High Court took the stand that in Assam 16(4)(a) as amended by 85th Amendment with effect from 17/6/95, by which government employees in the reserve they will get consequential. So, they will have to specify with the change in government. The earlier government's additional advocate general, he makes a specific, and in that case, it was a fight between the general and the reserve. We as reserve again won that case. My learned friend, Mr. Paresh Deka's case. No, I was for the. You were for the. No, he took. Paresh Deka. So, my lord, my submission is that the change of government, the additional advocate general will come and say, we will give, we will not give. My lord, my main arguments, which are because they have made their points, now I'll complete my argument. It is for a lordship to decide. This OM of 18 is a fraud on power. Why? It specifically says in clause 4, we will not give you reservation. We will give you reservation and promotion, rightly said. But we will not give you consequential seniority in the higher level, A class. And the A class in an engineering department starts from the assistant engineer, assistant executive engineer, the superintendent engineer, and as they go higher, and their yardstick is merit. If they are not giving it, means the categorical submission of both my learned friends is that 2002 is gone because the Pator judgment has given us the handle. Very good. So you remove it. In clause B, they say 2002 OM remains. For the C, D, E class, you will be given the benefit of accelerated promotion and consequence. Mala, what is this? Mala, is an OM operating for 50% and 50% it won't apply. For the higher cadres, no. So you are basically tinkering with Article 16(4)(a) because the 16(4)(a) has been upheld by Nagraj. The Assam government doesn't have the power now to do away with reservation in Assam. Only one course is available. And if they say, I withdraw my case, the chief secretary should give an open statement that we have removed reservation from Assam, then they will have to repeal the 1978 Act because the power flows from 75 Act. So in OM, they have not only overridden the Act, now they are overriding binding judicial decisions. So that is the vice. And in fact, there cannot be a catch-up principle now after the 85th Amendment. That has been made clear by the 5 judges of the Supreme Court in the Nagraj, reiterated by the 5 judges in the Journal 1 and the Journal 2. The Assam government doesn't have any power. They have a power only, either they make an announcement, public announcement that 78 Act passed by the Assam Assembly and the 2012 Act, which has come pursuant to R.K. Sabarwal post-based reservation is withdrawn.
2002 is an act or a notification?
2002, 12 is an amendment act. Because Indra Swani has made it clear, the government has the executive power to bring in policy on reserve. So where is the policy? Who has given you the power? You withdraw that 78 Act, I withdraw my case. But if I have a 78 Act, which is in operation, which is the Guwahati High Court in 1978, Honorable Justice Raghuveer Shetty's division bench, it's a valid law. it has got legislative competence
Under Article.
under Article
41.
16,
41.
entry 41. What
The
more?
state list.
So I will not, and it's an enforceable right because the Supreme Court, Honorable Justice Chalamashir, who was here, his judgment is very categorical that till the time if you don't enforce it, if you don't enable it, you have no right. But once you enable it with an act, and in Assam, we the reserve the power has been enabled, it's an enforceable right. That paragraph I'm going to read. Well, this is the judgment of the Supreme Court. It's clearly covered because by now I know their arguments. So now I am placing my last submission. It's for Lordship to decide. Paragraph 24. Judgment of Justice Chalamish, it is Chairman Managing, it is 2015. I have a copy. If I may read, Lordship. Copy it. Only we have a copy. We gave the list of books in the morning. Possibly. Well, if I may read. In the first instance, we make it clear.
Which para you are reading?
I am reading 24. Citation with yes. Central Bank. Well, these arguments were accepted by the single bank. The same arguments I am advancing.
Yes.
In the first instance, we make it clear that there is no dispute about the constitutional. Para 24.
Yes.
In the first instance, we make it clear that there is no dispute about the constitutional provision envisaged in Article 15 and 16, insofar as these provisions empower the state to take affirmative action in favor of SC/ST category person by making reservation for them in employment in a union or the state. The laudable objects underlying this provision is also to be kept in mind while undertaking any exercise pertaining to the issue touching upon the reservation of such SC/ST employees. Further, such a reservation can not only be made at the entry level, but is permissible in the matters of promotion as well. At the same time, it is also to be borne in mind that clause 4 and 4A of the Article 16 of the Constitution are only enabling provision which permits the state to make provisions for reservation of these categories of person. Insofar as making of provisions for reservation in matters of promotion to any class or classes of post is concerned, such a provision can be made in favor of SC/ST category employees, if in the opinion of the state, they are not adequately represented in service under the state. Thus, no doubt, power lies with the state to make provision, but at the same time, courts cannot issue any mandamus to the state to necessarily make such provision. It is for the state to act in a given situation and to take such a affirmative action. Of course, this is important. This is my case. Whenever there exists such a provision for reservation in the matters of recruitment and promotion, it would bestow an enforceable right in favor of the person belonging to the SC and the ST, and on the failure on the part of the government authority to reserve seats while making selection promotion, the beneficiaries of this provision can approach the court to give their rights enforced. What is to be highlighted is that existence of provision for reservation in the matters of selection or promotion, as the case may be, is the sine qua non for seeking mandamus, as it is only when such a provision is made by state a right shall accrue in favor of SC/ST. Well, here I will come to the submission placed by my learned friend Mr. Chaudhary about a judgment from Uttarakhand. Earlier, Uttarakhand was a part of Uttar Pradesh. Reservation issues come up from those states because there excessive reservation takes place and the general reverse discrimination happens. There, the facts are very right. Well, I am supporting the case submitted by my learned friend. There are no bandabas, no bandabas. Reservation, it's a right of the government. If they want, if they don't. There, what happened? When it got bifurcated, they took a decision will not give. Matter went up. The reserve, they went to the High Court. High Court gave a mandabus. The general went to the Supreme Court. Supreme Court rightly said, I support the judgment. No mandabus. But later, that position is not here. In Assam, we have a valid 78 Act. We have a valid 2012 Act. You don't amend, you don't repeal it. And this was the logic. This argument was advanced. So the learned Honorable Justice, learned single judge rightly said, you can do it only after express repeal. But what you do, you bring a OM of 18. Thereby what you do, you categorize the reserve into two classes. Well, it is unheard of. Possibly this OM is first in the Republic after 1950, I think, because you categorize top position, you will not get. Thereby you're overruling RK Sabharwal because on merit we get it. Down you will get, means you will get down, you will get 16.4, you go up. When you go up, we'll block you there because we want to form a quota for the general. And that has been deprecated by Saurabh Yadav's case in 2020. Same situation was there. Because when the general compete, reserve competes, they compete as a member of the unreserved. You cannot look into the birthmark that earlier you got consequential seniority, you will not get. This is the thing happening since 2000, all selection committee. But today, my learned counsel from the other side will agree, neither their clients nor our clients are getting any promotion. It's stalled. And many officers have retired. Their officers have retired more because we always take a leapfrog, we go ahead. Well, this is a very contentious issue. Now, if this OM is brought about, what more? Well, all hells will break loose because the reserve are waiting for a fruit and legitimate expectation. At that moment, 18 comes in. Mr. Langthasa, who wanted that I go as number 2, is brought down to 70. And if it's at that stage, I had no other alternative but to approach this court and say that at least your lordship will hear this matter. This is a very important matter. The state has to make their stand very clear. I don't want a blanket. Your lordship is very right when your lordship says it's not a judgment in rem. It's not a, the OM is a rem because it will affect. The government will also come up with their cabinet decisions. It will be tested. That's the beauty of the system. But the lordship will not, will pass an order protecting me at this stage because now it's a very crucial stage. All gradation list, my information just now is all gradation list of all departments. We will be affected. Now, we have no other alternative. For the second phase, we'll have to again come to the court because it will, we will be brought down. And the 78, the efficacy of the judgment is totally overruled. 78 Act there. Well, the government of Assam, at different point of time, in 16, when the earlier government was there, they took a stand. This government says we will not do. What is our fault? Why will benefit 16.4A will flow to everyone? Nagraj has said it has been upheld. What is our fault? That in Assam, you will get 50%. How you will get? The OM of 2002 will operate at the lower cadre. You will be brought up. As you are brought up, you will not be given at the higher cadre, A category. Because of entire purpose, that was my submission. The government wants to bring a quota for the general on merit, and Supreme Court has deprecated it. Judgments were given there. I'll place it here. So it is a very important issue. But today I want an interim protection. I'm not saying omnibus stay of the interim, but my lord, what all officers, my lord, my clients are fearing that all gradation lists are being brought down because your lordship has rightly said. Why
Your clients means how many petitioners are here?
Virtually in this petition one, but the other cases
Others are waiting in the wings.
Yes.
others are waiting in the wings because they expect me that after the judgment, the government had not implemented the order, so I have no other alternative as a lawyer.
But have you realized that if you get a stay here, others will not come to the court?
Malad, everyone will come to the Malad. My learned friend Chaudhary is yes.
Have you realized the consequence of that?
What consequence?
If a stay order is passed here, others who are waiting in the wings will not come to the court.
On which class, lordship? Which?
Your class.
But I'm confident my group will come because I was the single-handedly for the case on all departments.
That will have a serious consequence.
Yes. Acting like a messiah. Yes, Malad, in fact, my learned friend has given my name also. I was the Ambedkar. So these are the things, Malad. Well, our clients will go away after some time, but we'll have to stay here. That is
No, that's all right. That's on a lighter vein.
So I need protection. Where will I?
Championing Ambedkar is a good thing to do.
Yes.
Yes. But There are ways and means. But I think the championing Ambedkar, in my context, when this reference was made, I think it was not in. Because already the adversarial system was at its height. So I pray for an interim protection, and this is
What is the interim order you want?
Well,
Final,
at this
last.
stage, they will not give effect to this. That I can ask. When any
So what will
selection-
happen? If they give effect to it, what will happen?
Malat, if they,
When are they, how are they going to give effect to it?
Malat, they are going to implement the fact that they have already downgraded. And the very funny part is that on the day when the OM came, on the day only my notification also came, 18th, same day. So they brought it.
On the way.
And in fact, my information is that all levels they have bringing it. And they will take the stamp, 18 OM. We have a right, we have got a right from the single bench, the submission of money.
Yeah, but Mr.
So no selection at
That's
this
one
stage?
thing is,
But I have brought an important issue before this court. It's for your lordship to pass order, but if I'll be totally prejudiced because this is the second phase. But at least till your lordship examine, they will not proceed with the selection because or lordship, but the division bench matter till the division matter is not disposed of. Your lordship. will-
Just one thing. But in a case where a gradation list is challenged, on the very first day by an interim order, the final relief is not given by passing an interim order.
No, without the leave of the court, it will be under judicial
because-
scrutiny. Because anyway, if a selection is done,
You are challenging.
tomorrow I am coming up with the same grounds.
Your lordship will examine, but then today, if your lordship passes an interim means you are giving, lordship is giving the final relief.
Then what will happen? The government will start implementing the 18th. Then again,
When the
another.
government starts, will come for early
No,
hearing.
it's not, sir. But-
Early hearing.
Well, my submissions were not answered by Mr. Majumdar till now.
Around-
That why Assam
My-
government
my
has the
learning-
liberty of taking and enforce. And my lord, it is bound, it is bordering on irrationality. Irrationality is a ground of judicial review. On the higher cadre, you will get, you won't get, lower cadre you will get.
all right, so now it's time to dictate the order.
Yes, my lord.
Please take your seat. Heard Mr. D.K. Das, learned counsel, assisted by Mr. H. Betala, and counsel appearing for the writ petitioner. Also heard Mr. D. Majumdar, learned senior additional AG Assam appearing for the respondent numbers. Respondent numbers 1 to 6. 1 to 6, assisted by Mr. D. Nath, learned senior government engineer Assam, appearing for the respondent numbers 1 to 6. By filing this writ petition, the office memorandum dated 18/1/2023 bracket annexure capital G bracket close issued by the respondent number. Respondent number 4 has been put under challenge. Internally contending that the clause 4 of the memorandum of the OM dated of the impugned OM.
Two clauses as challenged, 3 and 4.
Have been put under challenge. First, according to the writ petitioner, who belongs to ST Hills, ST bracket H Hills category. Clauses 3 and 4 of the impugned OM are not only behoves the rules, but is also violative of the judgment and order dated 6/6/2022 passed by the learned single judge in WBC number
5005 of
5005/2016 bracket of Divo, third bracket Divo, Bhagavan Pator versus State of Assam and others. Full stop. Mr. Das, learned counsel for the petitioner, has argued that by issuing the impugned OM, that too at a stage when the judgment and order dated 6/6/2022 is under challenge before the division bench, the respondent authorities are not only seeking to take away the benefit of consequential seniority um, available to a candidate belonging to the reserve category, but has also, but is also contemplating consequential action by downgrading is reserve category candidates such as the petitioner so as to deprive them of the benefits of the fruits of accelerated promotion as a reserve category candidate. First up, by contending that there is no change in the state's policy as regards benefits available to the reserve category candidate, and more particularly in view of the operation of Section 5 of the
1978, Schedule Caste and Scheduled Tribe.
Scheduled Caste and Scheduled Tribe.
What is that? Appointment in post in.
Just ask him to give the
Yes.
Act of 1978. The improved OM is unsustainable in law and is liable to be set aside by this court. Full stop. Apprehending that the authorities may initiate consequential action and give promotion to other candidates of the general category ahead of the petitioner, a prayer has been made for issuance of an interim order. Full stop. In support of its above argument, Mr. Das has relied upon the decision in the case of chairman and managing director Central Bank. Then you'll get it from here, huh? Reported in so and so. Then Journal Singh and others reported in so and so, as well as it's a Journal Singh and others reported in so and so. Stop.
Well, Nagraj also I refer.
As well as Nagraj.
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 Because
M.
Nagraj
Nagraj
just
and others,
mentioned about Nagraj.
yes, we'll get all this here. Responding to the above, Mr. D. Majumdar, learned additional AG Assam submits that the improved OM is not only in strict compliance of the order dated 6/6/2022 passed by this court, but same is also consistent with the law laid down in the case of Nagraj Supra and Janal Singh Supra. Full stop. Moreover, submits Mr. Majumdar, the impugned OM lays down a policy decision of the government which has been categorically permitted by the learned single judge by impugned judgment dated 6/6/2022. Full stop. Since the impugned judgment is not under challenge by the present petitioner, he cannot claim any benefit which runs counter to the ratio laid down in the judgment in order dated 6/6/2022. Full stop. Next paragraph. A cursory reading of the pleadings contained in the writ petition and the documents annexed thereto goes to show that the petitioner is primarily aggrieved due to downgrading of his position in the inter se seniority list of superintendent engineers in the Department of Water Resources, Assam, consequent to the impugned OM dated 18/1/2023. Full stop. To that extent, it is apparent that the basic grievance of the petitioner is that of a seniority claim. Full stop. However, surprisingly, none of the candidates placed above the petitioner in the impugned inter se seniority list have been made party in this writ petition. Full stop. Be that as it may, since Mr. K. N. Chaudhary, learned senior counsel, assisted by Mr. N. Gautam, had appeared and argued and addressed the court in WPC number 5005 and 2000/2016, and considering the fact that the issues raised in the writ petition would have a relevant bearing on the interest of his client, though not made a party in this proceeding, this court had granted leave to the learned senior counsel to make his submissions on the law point, full stop. By referring to the decisions um, of the Supreme Court rendered in the case of Mukesh Kumar and another versus state of Uttarakhand and others reported in so and so, as well as in the case of Nagraj bracket Supra. Mr. Chaudhary submits that um, the decision as to whether the state would continue or not with a reservation policy, more particularly pertaining to the consequential seniority of the candidates belonging to the reserve category, is a matter of policy decision. And as long as the criteria is applied uniformly amongst the similarly situated candidates, a writ of mandamus would not lie on this behalf, full stop. Contending that the learned single judge has not granted any relief to the reserve category candidate in the line of what has been argued by the petitioner's counsel, Mr. Chaudhary submits that there is no scope for this court to interfere in the matter, full stop. Mr. Chaudhary has also assailed the maintainability of the writ petition by contending that the petition is liable to be dismissed merely on the ground of non-joinder of necessary parties, which is the departmental candidates placed higher than the petitioner in the inter-se seniority list, full stop. I have considered the submissions made at the bar and have also gone through the averments made in the petition, full stop. Since this matter has come up for motion hearing, it would not be necessary for this court to go into the excruciating details of this case, full stop. However, since the petitioner's counsel has pressed for an interim order restraining the respondents from giving effect to the impugned OM dated 18/1/2023, it would be necessary for this court to briefly deal with the contentious issues arising in this petition, full stop. I find from the materials available on record that by the order dated 6/6/2022, the learned single judge had disposed of two writ petitions, namely WPC number 5026/2016 and WPC number 5005/2016, by inter alia holding that office memorandum dated 12/3/2002 is still holding the field unless the same is expressly repealed by the state, and also observing that OM dated 3/6/2016 3/8. Yes. Has disposed of two writ petition by making the following observation. Page 105, double tick to double tick, 9. In para 7 of the judgment. It will be 7, then bracket Roman 9, full stop.
Start from page 104.
The aforesaid.
Start from page 104, para 7.
Then you include the entire para 7 by making the following observation. Para 7, 104 to para 8, 105, full stop. It would be pertinent to mention herein that by the OM dated 12/3/2002, the state had earlier
Page 46.
yes, decided to confer the benefit of promotion to the scheduled castes / scheduled tribe community government servants by virtue of rules of reservation / roster, along with consequential seniority, with effect from 17 June 1995. Full stop. Subsequently, by issuing the OM dated 3/8/2016, more particularly in para Roman 4, the government of Assam had provided that the government of Assam had provided as follows, page 65, Roman 4 to add. Full stop. The writ petitioners in both the above mentioned writ petitions who belong to the reserve category candidates were basically aggrieved by the by clause 4 of the notification dated 3/8/2016, insofar as the same seeks to deny consequential seniority by of accelerated promotion granted earlier in the circumstances noted in the OM. Full stop. It is in that context that the petitioners' counsel submits that despite the order, judgment and order dated 6/6/2022, the government of Assam, by issuing the impugned OM, has once again reiterated the same condition, and therefore the same is liable to be interfered by this court. Full stop. Full stop. A plain reading of the impugned OM dated 18/1/2023 goes to show that the same has been issued by taking note of the observations made by the learned single judge in paragraph 7 bracket Roman 9 bracket close of the judgment dated 6/6/2022. Full stop. The learned single judge has neither made any observation nor issued any direction to the effect that the candidates belonging to the reserve category would continue to get promotion, dehors the power of the state to review such matters periodically. Rather, the language expressed in para 7 bracket 9 indicates to the contrary. Full stop. Mr. Majumdar, learned additional AG, submits that the impugned OM has been issued in exercise of liberty and or discretion conferred upon the government by the judgment and order of the learned single judge. Full stop. On a careful reading of the impugned notification, I find force in the submission of Mr. Majumdar. Full stop. As noticed above, the core issue raised in this writ petition appears to be a pure and simple dispute of inter se seniority based on the rules and notifications as well as the statutory provisions that would be applicable in the facts of the case. Full stop. If that be so, such a dispute has to be decided in the light of the rules, notifications, and the statutory provisions by going into the competing claims of the rival parties. Full stop. However, such a recourse also would not be possible in this case, since the affected persons who are placed above the petitioner in the impugned inter se seniority list have not been implemented as parties to this proceeding. Be that as it may, the pleadings contained in the writ petition raises a number of issues which would have a relevant bearing in the rights and interest of petitioner as well as similarly situated persons in the future, and therefore this court is of the opinion that such issues deserves to be suitably adjudicated by interpreting the relevant rules and notifications. full stop. As such, the matter would call for further examination, full stop. Issue notice returnable in 4 weeks. Since Mr. D. Nath, learned senior government advocate Assam, has appeared and accepted notice on behalf of the respondents, no formal notice is required to be sent in this case. Extra copies be furnished to the learned departmental counsel, full stop, so as to enable him to obtain instruction and file affidavit. The petitioner is also granted liberty to implead the private respondents by filing appropriate application if so advised, full stop. Heard on the prayer of interim relief, having regard to the facts and circumstances of the case, I am not inclined to pass any interim order at this stage, save and except observing that any decision taken by the respondents for promoting the departmental candidates in the Water Resources Department by giving effect to the OM dated 2023 would be subject to further orders that will be passed in this petition.
My lord, in this matter, for respond number 3, I am taking notice. My lord. For respond number 3.
Actually, Mr. R. Dhar for responding, but standing counsel WPT and BC. And then you change it accordingly. Mr. Nath for 1, 2, and 4 to 6.
Yes, only one thing I'd like to add. The issues raised in Lordship has had pertains to seniority. It doesn't pertain to seniority, it pertains to merit, because clause 4 talks about merit.
The court judge has a discretion to record.
This is the Lordship discussion, but just.
But this is where, Mr. Das, we don't want to say anything more. You also need to rethink. Ultimately, this is a seniority claim. You may base your claim on notification X, OM that, but it's a claim of seniority.
No, but I don't claim seniority in the higher echelons. That was my case. Mr. Lanthasa will not claim seniority. He has already gone. It's a merit.
No, that's ultimately a seniority dispute. That's the
and also a
dispute.
constitutional.
But maybe the basis of your claim could be X, Y, Z.
Yes.
But ultimately, you have to get your seniority.
Yes.
Otherwise, you don't get promotion.
Yes.
Absolutely, it's a seniority petition.
And in fact, the benefits of 16.4 cannot also be denied to me.
In fact, if you want, I can dictate the complete judgment today itself. It's entirely a seniority dispute. But anyways,
But since your lordship is examining,
already given the view. The reason why some issues have been flagged at times in a little aggressive manner is to really pinpoint the real issues. You may have your opinion. As a counsel, you are entitled to have your opinion. They will also have their opinion, and the court will also have the opinion. And these opinions are always subject to further test in appropriate proceedings, and that will happen. But in this process, there are some footings on which these opinions are expected to thrive. The expressions in the order is an indicative of the footings, which are liable to be changed or reversed. But yes, we have to be very clear in what we want to say. Making hazy observations, hazy findings is creating more problem. So that is why I've been very, very clear that I do not think it is any other dispute rather than a senior. You are entitled to challenge that, saying that it's a wrong view. But if I do not express that, the entire proceeding will just be floating.
everyone has their own.
You see, because
Order by a coordinate bench.
because when a judge gives an order, it must clearly bring out what is being decided, what has been observed, what has been decided.
Yes.
Otherwise, it is multiplicity of litigation.
Now there is multiplicity of litigation.
So therefore,
There's
it is
a
not
consequence.
it's not a question of criticizing any judgment and order. We are all imperfect.
Yes.
This is an imperfect system. But the court must be very clear and categorical.
Yes.
That may be right, that may be wrong. There is always appellate forum. Unless the court is clear in what it thinks and why it thinks, what is the purpose of a judicial order?
Yes.
So that is why I have mentioned it. All right, I have mentioned it so that
Has already raised.
if you want, you can challenge it in the division bench.
Because as they have, they want the matter to be referred to a larger bench. They have also done it.
Yes, so maybe all these.
So it
issues
can
will come
happen
up.
to
Yes.
this side.
All right, all right.
We say obliged.
Deeply obliged.
You go. Miss Saika, do you really want to do this case? Or should I release it from Partner and send it to a regular bench?
Then also.
I think that will be good for
It
you.
will be a more difficult matter.
Why?
At least your Lordship had the entire matter, and my lord, I can just reminding the facts as well, and the law also. So many
Think
times
about
we
it, think
discuss
about it, whether you want
Here,
the matter to
when
be.
it will be reached, when it will be, other matters are still pending, my lord, nothing is going to happen. Your Lordship, huh? As your Lordship wish, my lord, but I want that if your the matter, if it's the dispute, my lord, then we will get the judgment anyway. But if it goes, my lord,
What are
again,
you
if the
saying?
loss.
Other courts don't give judgment.
No, my lord, other cases, your Lordship had some of the matters that have been still pending as it is, my lord. Nowhere it has been, my lord. Pharmaceuticals, others, other matters, my lord. Not a single matter is disposed of till for last few months.
All right, so you want to proceed?
This, yes, ma'am.
Right.
At least it will be disposed of. Other matters, not a single matter is disposed of, my lord, for last 4 months.
All right.
Yeah, my lord, that they have applied only for registration under the scheme, my lord. It is not a subsidy that after the registration, they will get subsidy. That is a subsidy application will be different. The
Yes,
scheme is, my lord, that I have prepared the salient points and list of that so that your Lordship can go through and my lord understand. That's 6 Savali. Should I read it, my lord?
just 1 second. This is item number 9, is it?
Yes, ma'am. Confirm about the other, बहुत गरम लागছে।
Yes. And you want the fan? You want the fan? You want the fan?
With my lord.
All right. Yes,
Yes. I'm just reading the salient points, my lord, first.
yes.
At Sixavali School is a unit of Vidyasagar Foundation Trust having its registered office at Dibrugarh. The Deputation School is a service sector enterprise registered in the Industry Department and has been
Matile.
duly registered under MSME Act bearing Udyog Aadhaar number so and so and so and so. So already it is, my lord, registered in the Industry Department and got the Udyog Aadhaar card, which is mandatory nowadays. Government of India announced a subsidy scheme, had notification dated so and so 2018 as Northeast Industrial Development Scheme needs in short, and 17 for industrial units in the northeastern region. Section 4 eligibility criteria, unless otherwise specified, all new industrial units, manufacturing sectors and service sectors, including biotechnology and hydropower generation units up to 10 megawatt located in NER will be eligible for incentives under the scheme. Section 5F, eligible service sector unit is an enterprise in the service sector that significant capital expenditure and has significant employment generation potential. That is the main crux of the matter, my lord. They should have significant capital expenditure and has employment generation potential. The petitioner's school has incurred significant capital expenditure and has generated employment to the tune of 165%. There, now it is more, my lord, at the time of my lord filing. There is no mention in the negative list that education sector is not eligible for eligible to get subsidy. The petitioner school, being an eligible service sector unit, had applied for registration under NEEDS 2017 on 1/8/2018. On 30 January 2019, the petitioner's application for grant of registration under NEEDS 2017 has been rejected in the second SLC meeting, holding that the school is an entity which is not permissible for commercial purpose. The Committee also observed that school cannot be an industrial unit. The petitioner's school is a trust for promotion of education, and as such, the school falls under the service sector industry category of needs 2017. In the cabinet meeting held on 28 February 2018 at New Delhi, the Honorable Prime Minister and its cabinet has approved the proposal of Department of Commerce to give focus attention to 12 identified champion service.
You're reading from which page? You're reading from which page? From which page you are reading?
Salient points I have given.
Uh-huh.
To know, as let's say directed, I prepared a note about the entire case. Yes.
What I say? Where is the note? Oh,
Yes. It just summarized, well, the entire case was summarized.
yes. Yes, please continue. Which paragraph?
I was reading 11, my lord.
Yes.
In a cabinet meeting held on 28 February 2018 at New Delhi, the Honorable Prime Minister and its cabinet has approved the proposal of Department of Commerce to give focus attention to 12 identified champion services sectors, including education service. In the application form for registration under a scheme, the column form of business enterprise in its drop-down menu contains various forms of business enterprise, including trust and society, and another column in the form name and address of the cooperative society chairman, secretary, trustees of the trust and society. That means not only industry, others can also, who was sufficient investment and employment generation, two criteria. Then they can apply and they will be put on the 12 identified champion. The trust has full property which is producing or yearly income like any other property for the business of running of school. The eligibility criteria defined in NEETS 2017 has clause 4.1 and 4.2. The petition school is not covered by negative list as specified in Annexure 1, clause 4.2 of the scheme. Clause 5, I'll come later on to the scheme. 5D of the NEETS industrial unit means any industrial undertaking or eligible service sector unit other than that run departmentally by government, which is a registered business enterprise under the goods of service tax. If they invest, the government will get from every child fees, 18% they are getting at GST. So if government gives subsidy also, within 2 years, they will get return of the.
That's all right, but the question is, are you eligible under the scheme? That's the only question.
Yes, that is the only question. Now I'm coming to the scheme, that is Annexure 1,
Yes.
Annexure 2. 1, Annexure 2 is with the Annexure 3, that is the scheme, page 28.
Yes.
I'm reading from page 29, which is in English. Notification. In pursuance of the decision taken by the cabinet in its meeting held on so-and-so, the government of India is pleased to announce Northeast Industrial Development Scheme NEETS 17 for industrial units in the Northeast region comprising states of Arunachal, so-and-so. Northeast Industrial Development Scheme NEETS 2017. It will refer to eligibility. Your lordship may please come to point 4 eligibility. Unless otherwise specified, all new industrial unit in manufacturing sector and service sector, that is important. Service sector including biotechnology and hydropower generation unit up to so-and-so and a year will be eligible for incentive under the scheme. The scheme shall not be applicable in the industries listed in Annexure 1, that is negative list. all eligible industrial unit will be entitled for benefit under one or more components of this present scheme, even if such units are getting benefits under other schemes of the Government of India. The total benefits from all components of the scheme put together shall be limited to the total investment in plant and machinery, subject to a maximum limit of so-and-so 2 crore plant and machinery for the service sector. Industrial units shall include cost of construction of building and all other durable physical assets, basic to the running of that particular service industry, but exclude cost of land and consumable, disposable, or any other item charged to revenue. Only new industrial units shall be eligible for the scheme. Your Lordship, please come to 5D. 5D money, that industrial unit means any industrial undertaking or eligible service sector unit other than that run departmentally by government, which is a registered business enterprise under goods and service tax. Then F, my lord, eligible service sector unit in an enterprise in the services sector that requires significant capital expenditure and a significant employment generation potential. That's the main thing, my lord. Your Lordship, come to the page 34, my lord, come to the negative list. The following industries will not be eligible for benefit under NITS 2017. All goods falling under so-and-so, pan masala covered by so-and-so, plastic carry bags less than so-and-so, goods falling under chapter 27 of the first schedule, central excise tariff so-and-so, plantation, refineries and power generation units, coke, cement, ash, steel rolling mills, units not complying with environment standards or not having applicable environment clearance, etc., low value addition activities like preservation during storage, cleaning, operation, packaging, replacing or labeling. Any other industry activity placed in negative list show a separate notification and considered necessary by the government. Gold and gold. So these are the negative list. Part 2 also there is that is not in the negative. So let us come to the my lord cabinet decision. That is in my lord page 39, annex 5. Page 39. The Union Cabinet chaired by the Prime Minister Shri Narendra Modi has approved the proposal of the Department of Commerce to give focus attention to 12 identified champion service sectors for promoting their development and realizing their potential. These include information technology and information technology. That is a kind of school also, my lord. Information technology. Enable service, IT and ITs, tourism and hospitality services, medical value travel, transport and logistic services, accounting and finance services, audio visual services, legal services, communication services, construction and related engineering services, environmental services, financial services, and education services. So, my lord, this is a high thinking, my lord. All items are not normally that this industry, that industry, this. All the items included in the list, my lord, of very, my lord, high value and my lord, this high thinking process of the latest technology. IT sector, accounting and finance service, all other services, my lord. So this school, somebody has opened college or school, accounting and finance services. They will also get benefit of the scheme, my lord. And audio visual services, they will also get benefit. It is specifically mentioned, my lord. So it is of not normal industry that I am open this industry, that industry. Not only that, my lord. All the items included in the list is, my lord, of different thinking, my lord. The cabinet also directed the ministries departments consult with these sectors to utilize the available draft sectoral plans to finalize, implement the action plan for the identified champion service sectors. The respective line ministries, departments shall finalize the action plan and the implementation timing along with monitoring mechanism to monitor implementation under the overall guidance of the Committee of Secretaries under Cabinet Secretary. A dedicated fund of so-and-so has been proposed to be established to support initiative for a sectoral action plan and the champion sector. In fact,
What is this you are referring to in page 39?
First paragraph, my lord, that
No, not paragraph. What is this document?
this is my lord, a part of it is available in the my lord website.
What
I've
is
done
this
it.
document? What is this called?
Cabinet decision, my lord. Cabinet approves action plan for champion sectors and services.
All right.
Updated, my lord. Posted on 20th February, so and so. Time is also given, my lord.
So where is the order rejecting your claim?
Relating to me, my lord. Education service.
Where is the order rejecting your claim?
Beg your pardon?
Where is the order rejecting your claim?
Oh, yes. That is, my lord, in registration is rejected, my lord. Not claim is yet to go, my lord. You want to say, please? Or, huh? 38. Okay, relate. 48, my lord, page 48. Please. Your lordship, can you see page 50, my lord? The relevant paragraph is the page 50. Point 5, the committee after a detailed discussion decided to reject the application for grant of registration under so-and-so for following one unit, name of the unit, Vidyasagar Foundation, Shiksha Valley School, Dibrugarh, East Dibrugarh, Assam. The committee was informed that so-and-so, Shiksha Valley, Dibrugarh, Assam is a service sector and is engaged in operation of day boarding cum residential school. Project was other thing. The committee observed that school is an entity which is not permissible for commercial purpose. The committee also observed that schools cannot be an industrial unit. After discussion, the committee rejected the application of Messrs. So-and-so, so-and-so, so-and-so. So, well, they are thinking, they might be thinking of industry only, not of this high-tech.
So any school has been given this benefit?
Not applied.
Not a single school.
Not applied for the, yeah. This is the only school. But other day, my lord, my friend who was reading 2007 scheme. I am reading my lord 2017 scheme. And my lord, we have applied in 2017 scheme. 2007 is of far away, and that is my lord, concept is completely different. And my lord, after this cabinet decision, which my lord followed by this scheme, my lord, is completely high-tech. If we read the, my lord, subject matter, it's one completely high-tech, which we normally it is not of industry. But then these are included, my lord, because my lord, number one is employment, my lord, because the government can employ only limited person. If the private sector comes up and they invest, and at least 10%, at least 5% people are employed, then only, my lord, government gets some, my lord, relief that some people have been engaged in the, my lord, industry sector. That's why, my lord, all these sectors have been, service sector has been included, my lord, in this scheme, so that people engaged in these sectors, they are employed. Employment security is there. Secondly, my lord, the government invested little money. Say, my lord, somebody will get 20 lakhs, somebody will 30 or maybe 50 lakhs also. But under the GST, they can recover if something is going on, because government is having income from these sectors. So under the GST, the school will continue for 40 years or 50 years. But, my lord, within 2 years or 3 years, the fees they are collecting and paying GST, that will be, my lord, another income to the government.
These schools are required to pay GST
Yes, my lord, 18%.
on what?
So
The
if
fees
there are
collected.
more school, government are having more income. Government is having more income for more my lord unit. That's my lord, the industries, they are also paying heavy my lord tax to the government. So government is encouraging for two sectors. One is my lord, government is having income if something is open. Otherwise, jungle will not give any income. And my lord, the people are also employed because in our country, lot of unemployment is there. Particularly Northeast, the unemployment is the highest sector. So my lord, it is included in the for the scheme is for the Northeast. And Northeast there is very high unemployment ratio because people are not doing many business or privately employed. My lord, employment is very less. Other state might not like Kerala, like Punjab, they are having private sector employment, lot of. But in Northeast, my lord, that opportunity is not there to the educated persons also. Here they have employed earlier, my lord, 165. Now they are having more employment. Only for registration.
So what is the capital employed by your school and what is the employment generation?
Employment generation at present 222 or something like that. 220. And my lord, earlier at the filing in my lord, 165. And capital is my lord. At least 200 families are having their bread, my lord, if they are employed.
And what is the capital?
And investment, 2 crores. Just a minute.
Page 51. Total employment 121 North. Page 50 out of the
165.
is in North.
Yeah. And investment. Investment. Page 60, my lord. They have taken loan on my lord. 853, my lord. Number of employment at that time was 157. 1920, my lord. Now, my lord, 200 plus. And page 60, my lord. CS certificate is there, my lord. Even 16 crore. Reminding them. 16 crore, my lord. Page 43. Come to application. Page 43 or let's say, can we see the investment? No, let's say month. I heard about it.
Yes. And how much will
then
you get if you're,
taking loan part.
so at the moment, the issue is whether you should get a registration or not.
Yes, ma'am. Only
Once
that
you,
much, my lord.
supposing the court agrees
Yes, ma'am.
and directs, then if registration is given, next will be the, whether the
Next
claim
one,
is,
whether feasibility, another.
claim will be
feasibility.
maintainable or not.
Yes.
That will be the next stage.
Next.
Hmm. Who is to give the registration?
There is an empire committee lordship.
And
Under the act, who decides lordship? In this case, the empire committee has rejected, and empire committee is not a party to the proceeding lordship. Empire committee consists of the secretary, Ministry of Industrialization. Then there is a representative from the Northeast Department of Central Government, Lordship Donna Ministry, and the secretary industry of the state concerned. They decide all this
Yes,
eligibility or not.
secretary has been made party because he is the, my lord, head of the committee.
And
Commissioner
lordship is
Department
not a
Justice
case of
and
hostile discrimination because not a single school has been given lordship.
Not
All-
applied
all
also,
that has
not
been
applied.
given-
They have entered, my lord, not applied. Nobody has applied. Because they may not be aware of the scheme, my lord. They have applied, others have not applied. Can you show? If somebody has applied and rejected, not applied, what to do?
All right. So what is your submission? Conclude you. Please conclude.
Yes, my lord. My submission is, my lord, that scheme says the, my lord, negative list also, that is their name has been absent from the my lord, negative list. And service sector include, and my lord, the cabinet committee meeting, my lord, cabinet decision, that is clearly, my lord, regarding, my lord, education is included along with other sectors, my lord, and newly included in this, my lord, scheme, my lord, which was published in 2018, my lord. And so, my lord, they should be allowed for registration. And another letter is there, my lord, where, my lord, they have sent a copy to the director secondary education. If it is not related at all, why they should send a copy to the director education? That is also there. Earlier also I submitted. So, my lord, my limited decision is, my lord, that they should be. That is of page, my lord. Hmm? 47. Director education there, copy this, yes, my lord. Copy of the minutes of the meeting, my lord. Copy of the minutes of meeting, my lord, sent to the, my lord, director of secondary education. If it is, my lord, not relevant, why he should be, my lord, a member of the committee and he should be. Page 47, my lord, not 47, okay. 46, my lord. Page 46, annexure 7, office memorandum. A minutes of the meeting has been sent. Subject minutes of the second meeting of the empowered committee held under the championship of Secretary, Department of Industry, Policy, Commission, so and so, so and so, consideration, so and so. Now, my lord, copy sent to the Donier, Department of Expenditure, Minister of Food Processing, Commerce, Ministers, Big Bhavan. Then, my lord, next page, your lordship, kindly see. Last 12. Secretary, Department of Higher Education, Sastri Bhavan, Dr. Rajendra Prasad Roniade. So, my education is on, my lord, relevant sector, relevant, my lord, department. That's why, my lord, they are sending the minutes of the meeting, my lord, to the Secretary Education also. Otherwise, my lord, other department which are concerned, only they will be sent. So, my lord, my line of placing the 2007 scheme last occasion, I'm trying to mislead this court, which should not be. And another, my lord, your lordship, earlier it was a very old case, my lord, where, my lord, the water supply, Bangalore water supply, my lord, case, there, my lord. Constitution means. In year 1978, my lord, a constitution bench judgment is there, my lord. Year 1978 Supreme Court 548, dear my lord, it's a constitution bench of 1, 2, 3, 4, 5, 6, 7 judges judgment, my lord. 7 bench judges judgment, my lord. Here it is, my lord, specifically held, my lord, that in the education is an, my lord, school is an industry, my lord. Industry as defined in 2F has a wide import, where there is a systematic activity organized by cooperation between employer and employees. The direct substantial element is chimerical for the production and for distribution of goods and services related to satisfy human wants and wishes, not civil censure. Absence of profit motive or gainful objective is irrelevant, be the venture in the public, joint, private, or other sector. It's a very long judgment. If your lordship want to see, my lord, I have marked it, my lord, ready. So few paragraphs, if your lordship allow me, I will read, my lord. You can listen here, my friend. Huh? Very long judgment, my lord. Paragraph 120, I'm reading and passing that book, my lord. The final ground accepted by the court is that education is a mission and vocation rather than a profession or trade or business. The most that one can say is that this is an ascertain which does not prove itself. Indeed, all life is a mission, and a man without a mission is spiritually stillborn. The high mission of the life is the manifestation of the divinity already in man, to sustain education as a mission, even if true. It is not a negate its being an industry. We have to look at educational activity from the angle of the act, and so viewed the ingredients of education are fulfilled. Education is therefore an industry. Nothing can stand in the eye of that conclusion. Yes.
Bangalore water supply case.
Huh? Even I person, yeah. Yeah. তুমি last time 2007 এর স্কিম দেখাইছেন। এই যে দেখাইছেন আমি পাই 2007 এর স্কিম। স্কিম 2007 এই লাস্ট এর আমাদের দিশা কত 2007 এর স্কিম এগন।
Needs 2017.
আমি তো এখানে করিয়েছি আমার ইয়ারফোন 7 এ CCIS এখন জানাবেন CCIS যেসব আমার এখন মোমো দেখুন দিলাম 2017 উপরে লিখছে আমি আপনার
Yes.
Another decision, my lord, this is regarding hyper-technical, 2005-10 SCC, 554, very short decision, my lord. I'm reading only one paragraph, paragraph 8. The scheme floated by the state releasing grant of subsidy for industrial unit to be set up in certain selected backward district area have a benevolent and public purpose to achieve, and that is to promote the growth of industries in such district areas which, but for the state encouragement, would continue to remain backward, and the industrial investment will not be attracted to such areas. Such schemes have to be construed with practical and pragmatic approach so as to achieve and not frustrate the purpose sought to be achieved. The benefit of the scheme ought to be allowed. If it can be done, the application should not be dealt with a hyper-technical approach or in a pedantic manner. If the application filed before the cutoff date is substantially in order and satisfied the formalities expected of the scheme, then an opportunity should be allowed to the applicant to cure the defects which are not of substantial nature or are capable of being cured, so that the deserving units are not left out of the scheme.
Yes.
So, my lord, they have filed the affidavit. In the affidavit, my lord, not specifically, my lord, said, but my lord, they have focused on, my lord, that education is not a, my lord, commercial activity. Education is, it is a learning community of motivated students and teachers. So, my lord, they focus on some other line, but why I have not been allowed, that has not been focused in their affidavit. I filed a reply, my lord, technical reply, my lord. And their school is an entity which is not permissible for commercial purpose, and that it cannot be an industrial unit, but it's just, it just goes against the judgment, my lord. That 7 versus judgment, constitutional one judgment, that goes against, my lord, this, the statement goes against the judgment, my lord. So actually, this is my humble submission, my lord. Because technically, my lord, whatever in the scheme, my lord, the legislature has announced the scheme with a particular aim and object, my lord, to develop some area. And my lord, if it is frustrated by the, my lord, executive, then my lord, it is a dangerous step, and my lord, this state will never develop, my lord. Because the legislature with certain aim and object, my lord, announces this scheme to give benefit to the people, to give benefits to certain sectors who are, my lord, by taking loan at high interest from different organizations.
So, supposing, let's assume that if your client is to succeed, what is the amount he will get as subsidy?
That I have not calculated, not.
idea?
Some meager amount, I don't think so, my lord, they will get, my lord, because, my lord, higher amount is, my lord, that 2 crores higher, again. Highest is 2 crores, eh? I will just check and after 5 minutes, I will.
Yes, Mr. Chakraborty.
Diason, here to the pie in this scheme and purpose.
Lordship, the scheme was framed with a basic idea of to boost industrialization, which will generate employment, Lordship. Lordship, I have furnished the cabinet decision, which last time, Lordship, which will speak for itself about the basic idea of the. Lordship, that must be in the file. You return to the thing, the 80 GB. Lordship, I will furnish them. Lordship, may come to page 2, Lordship. From top, Lordship. The evaluation agency recommended inter alia that focus may be given on promotion of micro, small and medium enterprises sectors as they contribute to a big way to employment generation. Focus may be given to states like Nagaland, Manipur, Mizoram and Sikkim, which receive less benefits. States such as Assam, Meghalaya and Tripura may be provided benefits under interest incentive and insurance scheme only rather than capital investment incentive also. Subsidized under
Mr. Chakraborty, before you proceed further, let me make it very clear. We are not going to discuss on whether they are entitled to subsidy or not. We are only going to confine our consideration as to whether the order by which registration was declined is a reasoned order or not.
Whether
If it is not a reasoned order, we'll send it.
Once they will get registration, they'll be entitled to get the benefit, Lordship.
Sorry?
Once they get the registration, they'll be entitled to get the benefit. That will follow, Lordship.
It is a process.
That will follow, Lordship.
Lordship.
We are basically on the vocational trainings only. That has been the intention of the cabinet, Lordship. This
All right, you please make a submission, yes.
Lordship, page
But
20
this
of
is not a
the,
part, this is not on record.
this is not, because it's a secret, Lordship, it's a secret document, it's written, secret,
Not on
Lordship,
record,
circulation, secret circulation, Lordship. On the basis of this, entire decision has been taken, Lordship. This Northeast industrial policy has been framed, Lordship. That scheme has been framed under this cabinet decision, Lordship. Page 20, this is a separate document, this is not entitled to the privilege.
No,
document.
but if you are relying upon him, then she's.
I furnish a copy to her, I furnish a copy to her.
But that
Lordship.
is not a part of record, my lord, because subsequently they have filed it. And my lord, I don't
If
think so
Lordship
that
wants-
as part
No,
of. it
but we will see everything
Yes,
that is
ma'am.
relevant.
Yes, Lordship.
Financial matters, there can't be technical grounds, you will not get it.
Yes.
Lordship, page 20 of this cabinet, Lordship, circulation, Lordship, page 20, Lordship. Incentive for service and other sectors, industries. This school comes under service sector, Lordship. Lordship, not page 20, Lordship. Cabinet decision, cabinet decision.
Yes.
May I read, Lordship? Incentive under ADIIPP 2007 will be applicable to the following service sector activities, industries, service sector, hotel, medicinal health, and number 3 is important, Lordship. Vocational training institutes such as Institute of Hotel Management, Catering and Foodcraft, Entrepreneurship Development, Nursing and Paramedical, Civil Aviation related training, fashion, designing and industrial training. So this will generate employment, Lordship. Not the school is a general, they doesn't create any employment general, then rather
So
than.
this is what is this?
This is the cabinet decision on the basis of which this policy was framed, Lordship.
No, but we'll, if you say it is secret, we'll have to quote all these things in the
Lordship, I
judgment.
I can bring that under an affidavit, Lordship. necessary.
Earlier scheme, my lord. 2007 scheme, my lord.
No, Lordship, Lordship, the heading may be seen.
NEIIP.
Lordship, the heading may be seen, Lordship.
Heading, you have put all this.
Northeast Industrial
No, no, no,
Development
no,
Scheme
no, no.
2017 itself.
No, 17 you have.
But
put
that is
the
the
first
problem.
page,
If you don't file it, then we'll not refer to it.
Yes,
We can bring this on record, filing an affidavit,
but my lord,
Lordship.
we have filed a scheme. Where is that? It is of any IRP, I have done many cases in any IRP and that is my 2007 scheme. They
Lordship,
have put the page together from here and there. It is specifically this page number.
That is
given.
why this document. which are
let
not-
us bring that filing an affidavit, Lordship.
Capital investment, no, if you file the affidavit also, but the giving the pages from 2007 scheme, that will be a serious consequence, no? Because pages are from 2007 scheme.
But why did you not file it so long? This matter has been pending since.
No, Lordship, it was only brought into record on last
It's the-
occasion, because it was received
Negative is
later on. Lordship.
2007. Other pages of 2007, my lord. If you will also see in the left side, my lord. NEIP scheme. How can he read that, my lord, the incentive?
No, what to do, Ms. Saika, if he is relying upon a document, what to do? The only
But
way
there's
is
some-
we can give him
There's
some.
someone, they have, my lord, the 2007 scheme, left side it is 2007 scheme. How can they
Correct,
manage
but
it?
that
They are
argument can
misleading the
be.
court, my lord. I have got serious objection about this.
Lordship, on the background
Because-
part, it has been stated 2006 extended up to
2007.
2017.
Left side, same page, your right side from, right side you are reading, left side you see the, that secret file number so and so. That is 2007 scheme. Last income tax exemption, 100% income tax exemption to NEIP 2007.
That is why a responsible person should file it on affidavit saying what is the document. Then only if you have an objection, the court
So
can
one
deal
week
with
time
it.
may be given at least because so many months they are and my lord, judgment will be passed.
Lordship, it's
Because
to come
you have-
from this
Why you
affidavit
have
has to
added
come
like
from
this?
Delhi, Lordship, not 1 week will not be enough, Lordship.
You mail it and he will courier it. You mail it after preparing the affidavit, he will courier it.
No, these are not court proceeding talks, Ms.
Okay, why you have put this 2007 scheme, why you have put, that should be rejected, my lord. That should be true. Why you are putting this 2007 scheme document with this 2017 scheme? There is no such clauses. You are reading from the 2000, in the top of the incentive and service sectors. Incentives under NEIP 2007 will be applicable to the following service sector. You are reading from 2007 scheme, your lordship may kindly see. Why they are misleading the court? I have got serious objection about this. This is a 2007 NEIP. So what is the need of giving further time, my lord? I don't think so, my lord, there is some. They should not be given further time. My lord.
Heard Ms. N. Saikya Leonard counsel appearing.
Reading from 2007 scheme.
This is item 9. Heard Ms. N. Saikya Leonard counsel appearing for the petitioner. Mr. B. Chakravarti Leonard CGC appearing for the respondent numbers.
All the respondent.
Appearing for the respondents. In course of his reply
Oh,
argument.
state,
has-
Lordship, there is a state, Lordship. Only 2 and 3, Lordship.
Respondents 2 and 3 and your name please. Mr. A. Kalita. Mr. A. Kalita, Leonard SC Industries Department is present on the respondent number 1 and 4. First up. In course of his reply argument, Mr. Chakravarti has relied upon certain documents and circulars of Ministry of Commerce and Industry, which throws light on the basis on which the NEIDS 2017 was basis of NEIDS 2017 to contend that only the vocational educational institutions can be considered as a part of the service industry under the scheme. However, since such documents have not been filed on the basis of an affidavit, the petitioner's counsel is handicapped in addressing such, in dealing with such argument of the respondent's counsel. Full stop. Mr. Chakravarti submits that he has recently received these documents as a result of which same could not be brought on record earlier. Be that as it may, considering the nature of controversy involved in this proceeding and the fact that the petitioner has a financial claim I deem it appropriate to grant reasonable time to the respondents to bring the said documents on record in the form of a short affidavit. The affidavit on behalf of respondent numbers 2 and 3 shall now be filed on or before 9th of February 2023.
Lordship, can it be like within 14th, Lordship?
On or before 14th of February 2023 by serving an advance copy upon the petitioner's counsel. This matter be listed again on 21/2/2023 for further hearing as a fixed item. The petitioner may file rejoinder in the meantime if so advised.
NEIIP 2007, my lord, not 17. NEIIP 2007.
NEIIP 2007.
2007.
NEIIP 2007.
7.
Yes.
All right.
My lord, on the case, my lord, of forced resignation from the border security force, my lord. The petitioner, my lord, alleges that he was forced to resign from the service, my lord. My lord, he had joined the service of the BSF in 1989. And in the year 2003, my lord, after having to undergo some punishment, he was thereafter forced to tender his resignation. He went and approached the, my lord, the civil court at Punjab and Haryana. There, my lord, he won the civil suit. But on appeal.
Okay, how long will you take? I'm not keeping it part-time. 20 minutes you will get to finish off both sides.
He says it will take time. Otherwise, I would, my lord, only emphasize upon one point, my lord, that he was not given any counseling before acceptance of the resignation.
Okay, you start, but I'll not keep it part-time. If you can't conclude, then we'll go waste.
Lordship consider a short date then. Matter is of 2011. He was terminated in 2003.
What remains in
Well,
this case?
now, as I see it, well, again, it will come down to only the pension part. Because he had 13 years of service. Now he's 20 years out of service.
So is there a prayer for pension?
My lord, that prayer exactly is not there. That was the prayer when he filed the original suit. Here, my lord, this was setting aside of the order accepting his resignation. So that other part would follow from this honorable court.
Then let him obtain instruction on that.
We can take some instruction on that.
As an alternative relief, whether the petitioner can be granted some pension as per section 49 of the CCS pension rule 1972. Why don't you obtain instruction on that?
I can obtain.
Heard Mr. R. Majumdar, learned counsel appearing for the petitioner. The instant writ petition has been filed agreed by an order of discharge from service by terming that the said order was forcefully obtained from the petitioner. Full stop. It appears that the petitioner was discharged from service way back in the year
2003.
2003, and the writ petition itself was filed in the year 2011.
He had pursued his cause in Punjab.
Whatever be the reason, considerable amount of time has already lapsed, and therefore it may be difficult to reinstate the petitioner in service, even if a valid case is made out. However, this court is also conscious of the fact that the CCS pension rules do contain provisions for payment of pension in case of employees whose services are prematurely truncated on grounds such as resignation and
Resignation doesn't get only retirement,
voluntary retirement or discharge. Full stop. Although no such prayer has been made in this writ petition, yet this court is of the opinion that there is scope for granting alternative remedy alternative relief to the petitioner uh, after hearing arguments of both the sides, full stop. Therefore, Mr. H. Gupta, learned CGC, is directed to obtain specific instruction on the aforesaid point and address the court on the next day. Please let this writ petition be listed again after 4 weeks or a non-miscellaneous day as a fixed item.
I'm obliged, madam.
May I please, in this matter, my senior officer, T.J. is supposed to argue, but he is on legs for a division bench also.
Today, your lordship.
Any day next year. What remains in this case?
In the nothing, petition can be closed, my lord, because they also paid the admitted amount. Only thing that your lordship asked the Celtic department to make an inquiry and inquiry report submitted. And dispute relating to the VAT. Let the department take appropriate action. If I am entitled, I'll get it. If any refund.
They have
It can be
already,
closed.
they have already paid the amount.
Where? In Celtic? No, they have not.
So what is now live in this case?
Because in case it can be closed, my lord. There was the admitted amount they paid. And only thing that it can be closed by with an observation that the department will proceed in accordance with law. Celtic department, because there is a report on this code.
You ask him, he'll look at the door.
I have to take instruction from the senior officer.
Let it be
Next week.
Let it be any other day.
Not Mr. Escott, learned counsel. You are for the respondent.
Yeah, I'm for the petitioner.
Petitioner. Also heard Mr.
A. Bulwa.
A. Burwa, learned counsel for the respondent, who submits that his senior is on legs in another court and therefore this hearing of this matter be adjourned for 2 weeks. After having a cursory glance of the statements made in the petition, it appears that there is scope for closing the matter without a full-length hearing, subject to the condition that parties agree to the recourse suggested by this court. Since the respondents' counsel has prayed for some time to obtain instruction, let this matter be listed again after 3 weeks.
Okay.
I can play.
Also, this is a dismissal matter, it will take some time, lordship. So, lordship has to go through the record also. Any other date, lordship?
You choose the date. Had learned counsel for both the sides. On joint request, this matter is directed to be posted for hearing
9th of February.
again on 9th of February 2023. Final hearing.
Department is proceeding, my lord. I will remove for service after department proceeding. Take some time, my lord. Take some time, my lord.
No, what is?
No, it's not possible.
Can you choose a date?
Sometime 13 matter will early date may be given.
All right, 7th February.
7th February. All right.
List this matter for hearing again on 7th. On the request of petitioner's counsel, this matter stands passed over for the day. Miss
P. Rama on behalf of A guy.
Ms. P. Rava, learned counsel, is present on behalf of the respondent.
Lordship, kindly pass over the matter for the day, Lordship. Kindly pass over the matter for the day.
The only difficulty is this, Mother, the petitioners are going to be declared one in 31st January. and another in the month of April, and third one in the month of July, my lord. This is what the problem I have, my lord. Now she's afraid for.
No, what is the matter?
Matter regarding, my lord, my promotion to my next higher grade, my lord, and the challenging the seniority list. The thing is that, my lord, the person, the respondents who did not be recommended by the APSC for the another department, PWD department, my lord, they were absorbed in this, my lord, they veterinary and animal husbandry department, my lord. And they are put above me in the seniority list. They said a provisional seniority list has been published. But my lord, I'll show your lordship, there is no publication of seniority, though it is required. A provisional gradation list should be published. Objection should be invited.
No,
then it
no,
should
1
be
minute.
finalized.
There is only one petitioner here.
My lord, there are 3 petitioners.
3 petitioners.
My lord, my lord. 1, 2, and 3.
What do they want?
My lord, 1 and 2. My lord, 1 and 2 only. My lord.
They are serving which department?
My lord, they are serving in a animal husbandry and veterinary department. My lord.
All right,
And
then,
my lord, yeah, the respondent number, my lord, 4, 5, and 6. As per recommendation made by the PSC, they are, my lord, recommended in the PWD department. But how they are, my lord, absorbing the veterinary department, and they were, my lord, put above us in the gradation, initially, that has not been answered by the respondent in their affidavit. Rather, they admitted my position. Well, yes, that has been done. Now, this matter came to my notice, my lord, when, my lord, order was issued on at page 33, my lord, saying that the provisional gradation list has been finalized. Finalization of gradational list. If your lordship look into page 33.
when was it finalized? When?
My lord, they said it is on 3/12/2014.
It was finalized on 3/12/2014.
14, my lord.
And it came to your notice
My
when?
lord, then we filed an application under RTI, seeking all the details, my lord. Now, if your lordship look into the RTI reply, my lord, that will be clear to my lord, my lord.
All right,
All
now,
the documents, all the gradation list, all the.
What is that you want now? What is the
My
order
lord,
you want?
what I want is that, my lord, this gradation list, that, my lord, the final seniority list, which was stated to have been finalized in 2014, should be interfered with. Let the matter be remanded back to them. Let them hear everything, my lord. More particularly, in view of the recommendation made by the APSC, that the respondent number 4, 5, and 6, they are recommended for the PWD department, how they could be, my lord, absorbed in the veterinary department and put above us in the seniority list, which they stated to have been finalized in 2014. Thereby, my lord, eliminating my chance of promotion to the next higher grade of assistant engineer.
So the matter will have to be heard.
My lord, if your lordship, my lord, gives that a direction, my lord.
Then if all of you agree, then I'll pass the direction.
My lord, but this matter must be looked into, my lord, how that their recommendation by the, they should not, in my
Today,
humble submission.
can you complete your argument?
My lord, I can just speak to my lord, list of the dates, my lord. I have just, they have filed the affidavit also, they have admitted everything.
Who is for the private respondents?
They did not appear, notice has been served, my lord. Only one respondent, their name is shown in the cause list, they did not appear. But others, notice has been served, but they did not appear, my lord. Notice has been
Now,
served.
somebody is retiring on 31st January.
Yes, my lord, 31st January.
So you want the court to decide this, pass a judgment, and then matter should go back and he should be considered for promotion.
So it may, or my lord may decide the matter here also. I leave it to my lord, but because of this, my lord, that the time factor, my lord, that's.
Time factor, 31st January means it's over. What can be done?
Yes, my lord.
That's go over. And the other petitioner?
The other petitioner, my lord, he is going to be declared in the month of, I think, my lord, March or end of March.
So we can at best give you a date on 7th of February if you want.
Or if your lordship may take up the next week sometime, my lord, or otherwise with that direction, my lord, that may be this recommendation made by the.
Mr.
Lordship.
Be reasonable.
My lord.
Your client cannot get anything from this court.
My lord.
Question doesn't arise.
Yes.
Since 2017, he has been sleeping.
Yes.
Now, 1 week before retirement, he wants a
My
quick
lord,
judgment. Not
my
possible.
lord, we have tried for the listing of this
No,
matter. But
can't
see,
help
my
it.
lord, that is been.
Can't help it.
My lord.
This is what the system is. When do you want? Tell me.
In the first week of February, my lord, if your lordships.
On the request of Mr. Vijay Ghosh, learned counsel for the petitioner, let this matter be listed again for hearing in the first week of February 2020.
Yeah, date may be fixed, lordship, otherwise it's very.
7th of February.
Almost.
May I please?
May I please, my lord, I am for my lord, respondent number 3, my lord. One affidavit in reply, my lord, filed yesterday, my lord, it is not in the record.
In this case, lordship, we have changed the deputy CLC's order, lordship, whereby they have enhanced the
Today, this is not possible, my lord. And our reply is also not on record.
Learned counsel for both the sides are present. It appears that the affidavit in reply filed by the respondent,
Three.
number
3,
Respondent number 3 yesterday, that is
yesterday.
give the date, is not on record. Office to comma therefore comma full stop office to comma therefore comma trace out the affidavit in reply comma tag with the record of this case and list the matter thereafter for hearing.
interim order.
Interim order passed earlier to continue.
May I please, Your Lordship? This matter is pertaining to promotion from senior account assistant to accountant, Lordship. My lord, although I was first in the seniority list, Lordship. My lord, the respondent number 6 was the second, but he has been promoted. My promotion has been denied, Lordship, on the ground that my earlier promotion was on accelerated promotion by way of reservation policy. That your Lordship has already gone through the item number 21. My lord, that the issue has already been decided by the learned single judge of this honorable court, Lordship.
So now there is a OM. OM dated 18-1. In view of that, this has become infractions. You have to challenge the OM.
But 18-1, Lordship, I have not.
18-1-2023, there is a OM now. No accelerated seniority.
That one may come to his favor also.
You examine it.
My lord,
On the prayer of Mr. M. Khan, learned counsel for the petitioner, seeking time to examine the latest office memorandum dated 18-1-2023, issued by the government of Assam in the Department of Personnel. This matter stands adjourned for 3 weeks. Mr.
AK Talukdar.
AK Talukdar,
Number 6.
counsel 6, Upar Divo, Mr. Nayak for
1, 3, and 5.
Mr. P. Nayak, learned government advocate Assam for 1, 3, and 5, and Ms. M.D. Bora for respondent number 4. Attached to Mr. AK Talukdar, list accordingly.
My lord, against the single bench judgment, the appeal is already filed today, your lordship's heard, my lord, no? Whether it should be better to wait for the judgment of retail.
That we'll see next date when it is listed. Let him examine first.
Yes.
Not, can it be in the second week of February, Lordship? Second week of February, Lordship.
It will come, it will come. Nothing is going to happen now. No promotion you will get till that is settled.
This matter pertains to an award passed by the industrial tribunal. Award is today probably it will not be possible.
Award, what award?
Award of the industrial tribunal,
Election tribunal,
industrial tribunal.
industrial tribunal.
Either your lordship may keep it part or fix a
No,
date.
no, why? There's no hearing.
And that is why.
You take, you fix it, take a date on 16th February. 16th February. 16th February? All right, Mr. S. Dasgupta, learned senior counsel, assisted by Ms. Vidas is present for the petitioner. Mr. G. N. Shaivala, learned senior petitioners, Mr. G. N. Shaivala, and senior counsel.
PJ Saihola.
PJ Saivala is present on behalf of the respondents. This matter could not be heard today due to paucity of time. As such, registry to list this case again on 16/2/2023 as a fixed item for hearing.
Perhaps due to paucity of time.
16.
Today is
Due to
not
paucity of time, this matter could not be heard today. List again on 16.
public.
This matter could not be heard today due to paucity of time. List again on 21. 21st February for hearing. That's all.